So this top of the list items.
Next week, Monday, my lord.
There is hardly any chance of accommodation. 2011 matters.
My lord, my senior difficulty is bereavement. One of his relatives.
Well, I've been here in this case.
Item 1.
I have not gone through the petition also.
So Monday then next.
Yes. My lord, I am for item 2.
No, item 2.
I mean item 1.
No, mentioning 2. You're taking consent of the other side.
Yes.
Both sides are represented. Mr. K.R. Barwa, counsel for respondent number 1 to 6, have submitted that. Mr. P.K. Kalika, senior counsel, is in bereavement and accordingly pays for adjournment. On the said ground, prayer is allowed based on next Monday. Okay. 4. Okay.
410.
Okay.
Obliged.
Yes, you are mentioning item.
Item 2. So I'm sorry, ours is item 1.
Item is 2010 matter. I think
10, madam.
this is RFI. I think if you sit here for half an hour, you'll recollect everything.
Well, I'm not ready. I'll have to read it. Lord, should we take it at 2 o'clock then? I'll let this. 2 o'clock.
Okay.
In the meantime, I'll just go through. Let me see if I can.
Okay.
Lordship, I beg to mention to tag often affidavit in item number 8. So, Lordship, kindly matter may be taken up after receipt the affidavit. The matter may be taken up after receipt the affidavit, Lordship. Lordship, with regard to item number 34, my lord, there are some difficulties, my lord, of my senior, my lord. I have taken my consent from the.
34 is a transfer petition. No. We are not adjourning.
My lord, can it be on Friday, my lord? Please, not well, my lord. Actually.
It's okay. Transfer matters are from 22. It is pending. No, you renew the prayer when the matter reaches.
Lordship,
You see that.
my lord, can it be, my lord, on 30?
You renew the prayer when the matter reaches. I won't adjourn unless I read the.
For listing of 2 items. One
This thing give it to the court master.
Lordship, I beg to mention one RSL Lordship for listing. Lordship.
Please hear me when I am making a statement. You have heard me in the last
Sorry,
matter.
With the consent of the other side, my lord, I beg to mention item number 35, my lord. Let me pass over for a day, my lord.
No, these matters are stay matters. You renew the prayer when the matter reaches.
May I please, your lordship, my senior is in bereavement. So lordship, may kindly pass forward a matter for the day.
Which matter? All the matters.
Item number 18 and 19.
18 and 19. Okay. I
Lordship,
thought you were
item
mentioning for
number
the entire
19.
list. 18 and 19. Okay. In item 19, you have taken consent of the other side.
Yes, lordship. We have taken the consent of the council. For item number 18, the council for the respondent side has not been reflected in the constitution.
On behalf of the counsel for the appellant, we submitted that Mr. R.K. Bhuya, counsel for the appellant, is in bereavement. Matter is adjourned today. List in the next week. Yes, Mr. Chauhan.
My lord, item 10 even may pass over for the day. Item 10 and 11. And this council, he has some personal difficulty.
Item 10.
Yes, 10 and 11.
You taken consent of the other side.
My lord, I think my lord, engaged counsel, he has taken. I'm not done with this discussion.
Okay. You are making prayer on behalf of. You are making prayer on behalf of.
Engaged counsel, my lord.
What is the name?
Bhakto hai. He has requested me to pass.
On behalf of on the prayer made by Mr. S. Chauhan, counsel for the petitioner. Public appellant, matter stands adjourned today, just in the next week. Okay.
Obliged. Various item number 3 for motion.
This is a transfer petition, Melon, pending before the Lanet Court of Excellent District of Sunit.
No, this transfer petition, section 24. P. Burman, counsel for the petitioner. Application under section 24 of the for transfer of matrimonial proceedings being so and so on the court of
Additional district judge, Sunit.
additional district judge in bracket FTC Sonitpur to the court of to where
Sunit.
to, from where to where
To family court, Kamur.
family court Kamrup to family court
Matrimonial matter, madam.
family court Kamrup Metro Guwahati. Notice steps within in course of the day.
I have a prayer for stay or something.
Okay, till the next return of the proceedings of shall remain stayed.
Or
It is made clear that if steps are not taken by the learned counsel for the petitioner, the stay will not be operated. List
item
on
number
also.
4. 4.
Yes,
And if
we're expecting some comments.
this is very interesting, madam. Order 9
No.
rule 13.
Because you see, order 9 rule 13 in appeal.
Yes, no, the order 9 is for setting aside a decree, not for any other order. Here there was an order.
Now, since there was an application, there was an order.
So order 9
You
13 is
invited,
not, order 9 13 is not applicable. But still we have, instead of challenging that order directly, we have filed it because in the condonation petition, so many observations have been made. Now, if those observations remain, even if I want to challenge the main order, the court may say that there are so much of observations by the court.
no, this, now you are challenging 24/7.
24/7.
So it will be again a challenge to an order which is without jurisdiction.
That is correct. I only
Then
wanted to.
why should you entertain it?
Basically, yes. Basically, my prayer is very simple. I have indicated in the synopsis also that we would like to challenge the main order in the.
No,
appropriate
that
forum.
you can't do. If its order is non-est
Yes.
or without jurisdiction, then you don't have to challenge the observations.
That is
You
there,
take a
but
call.
Lordship may kindly have a look at the order passed in the.
No, whatever be, if it's a court without jurisdiction or an order without jurisdiction,
Minor.
why do you have to challenge the contents of the order?
I know that, but I'm still challenging because if that order remains.
No, the challenge would mean that the order is lawful. Then you have to take the consequences of that order.
Now, what I want is an observation from this number court that I want to challenge that, and I want a liberty only.
No, but
nothing else.
nobody is preventing that. You see, when an order is without jurisdiction, can somebody bar you from
No, no.
taking the appropriate remedy?
That is there. I still, instead of challenging directly that, I want that some observation from some report that even if the order is passed in the way your lordship is saying, that also will help me. I will go and challenge the order. That's what I'm saying.
No, you see, you can merely make a prayer to withdraw it and approach the appropriate court.
That also can be done, but if something is observed by your lordship that I am withdrawing it because of this.
So that will we put it in your mouth.
Yes. Yes.
Instead of court making any observation, we'll
Yes.
permit you to take that plea.
Yes, ma'am.
No, this I have acquainted myself with this list of dates.
Minor.
I have
separate.
equal and distort dates here for your matter.
I have put it because things are in
Because
such a design.
from your synopsis, I could not understand anything. Because I couldn't understand the nature of challenge. So therefore, I had to read your brief and then.
The
So permitted to
order,
withdraw it and challenge it before the
Minor.
Learned Trial Court,
yes, I'll
before the appellate court.
yeah, yes. The order by which I am aggrieved is
That is 74 and 73 and 74. That is.
my lord, 9
9, 12,
2016 is the order I am aggrieved by.
Yes.
So as against that, order 913 will not lie. It is the revision will lie before the submission.
Hmm.
Only lots will mention that I am making that submission and therefore I am withdrawing. That will suffice.
Heard. Mr. D. Mazumdar and his senior counsel, assisted by Mr.
G.R. Datta.
G.R. Datta, counsel for the petitioner. The learned senior counsel for the petitioner has submitted that his predecessor was arraigned as defendant. You're right, predecessor
yes.
was arraigned as defendant number 1 in a suit for declaration and permanent injunction, which was registered as
TS number
TS
52 of
52 of 2012. In the said proceeding, by an order dated 4/10/2012, passed in the proceedings of, what is the case number? Miss case?
Miss case is 7 of 2013.
7 of 2000. No, 7 of 2000 violation.
Violation, yes.
No, that status quo was given where?
Status quo was given.
It's not there in your list of dates.
It was there, madam. Four 10/2012 mentioned, madam, in the third item, madam, towards the end, alleging violation of the temporary injunction order status quo passed by the trial court on
What is case number? Case number.
Miss case number 8 of 2012.
Okay, I will read it. 4/10/2012. Passed in this case number
8 of
8 of 2012.
in the TS number 52 of 2012.
Full stop. The title system of 52 of 2012 in the meantime was dismissed by judgment and decree dated 30/11/2013, passed by the Court of London, Masjid number 2, Kachhar, Silchar. Post agreed by the dismissal of the suit, TS 60 of 2013 was filed by the petitioner. Sorry, the respondent plaintiff. Post the said appeal was allowed ex parte, right,
Yes, ma'am.
by declaring the suit. Post. The decree is dated 9/12/16. 9/12/16.
Yes, 9 to
9/12/16, passed by the London Civil Judge number 1, Kachhar, Silchar.
This 9/12/16 was passed in my absence, but then appellate order was by the appellate court passed the order in presence of both the parties. title appeal was allowed, declaring the suit in after hearing both the parties.
It's not expiring.
And it was-
It's not expiring. Next paragraph. The proceedings of Miss Case number 7 of 2013 filed under Order 39/2A CPC were dismissed by order dated 10/3/2016, against which the respondent plaintiff filed Miss Appeal number 7 of 2016. To stop. It appears that although the appeal was allowed by the learned civil judge number 1, Kasar Silchar, being Miss Appeal number 7 of 2016, apparently no relief was granted in the appellate order. Full stop. Nonetheless, before
This
the court
order-
of learned Musif,
This order was passed without issuing notice.
this order was without notice. Okay.
Yes.
Full stop. It is the learned senior counsel for the petitioner also submits that the said order was passed expiring without notice to the petitioner. At that time, your predecessor interest was there.
Yes.
No notice to the predecessor interest of the petitioner. Next, in the meanwhile, the proceedings of misviolation case number 7 of 2013 was restored to file, and notice dated 28/4/2017 was issued to the petitioner to appear before the court of London, missive number 2, on 3/6/2017.
To show cause.
Full stop. The petitioner filed miss case number 73 of 2017 with the predecessor of petitioner filed miss case number 73 of 2017 under order 9/13 CPC, read with section 151 CPC for setting aside the ex parte order dated 9/12/2016. But why 9/12 was challenged again? You said that you are not agreed by 9/12.
I'm agreed by 9 till this was allowed. The injunction violation petition was dismissed by the first trial court. Then the appeal was preferred and no notice was issued to me, and that was allowed. I am agreed by that order.
You just see that order. So you are agreed by what?
Agreed by this order 9 to 2016.
You read that order.
Well,
Last part you read. What did the court do?
page 62. Man.
You read that order. See, the appellate court allowed the appeal
Yes.
and did what?
Hence, I find that there is a scope for interference in the imperial order of the land trial court, lower court.
I understand.
Then actually appeal is allowed.
I understand. But by allowing, what did it do? It did not pass an order of restoration of the case. It did not give any direction in the appellate order. That appellate order is not executable.
No, once the appeal is allowed, and that is why the notice is issued now. Of course, I can challenge that this order on the ground.
You see,
My lord,
that order was dismissed.
my lord.
The appeal is allowed. Even that this case is not restored.
And that should have been done. Or in the appeal also, they could have said that yes, there was a violation of the injunction order. So
You revive that that application is also not done. So what this you are agreed by what?
technically, I'm technically agreed, but then this order is of no consequence otherwise. It says appeal is allowed only.
Appeal is allowed.
Appeal is allowed.
Be happy with it.
They are also happy. However, without cause, send back lower court's record along with it. Vague otherwise. Send back to the lower court.
To
Now,
do
what
what?
does it mean? Very, very vague.
But Mr. Mazumdar, you can't.
No, Balutin, if there is an observation that I have violated the order, I'll be agreed.
But technically, I can't advise you.
Lordship, you mentioned that if necessary, we may not file, but then let us have the opportunity to file the revision AP for this.
No, because you see, I'm asking you for a reason.
My lord.
This, this was dismissed.
Yes.
This appeal was allowed.
Yes.
The order didn't.
Order 9/12/2016,
9/12/16.
page 62.
Oh, yes. 9/12, the appeal was allowed. Appeal being this case, the miss appeal number 7 or 16 was allowed. In the said context, the Learned Senior Counsel has submitted that although the appeal was allowed, but no effective direction was issued by the appellate court, i.e. Civil Judge number 1, Kachar Silchar. Nonetheless, the necessary in the interest of the petitioner, who was the defendant number 1 in this suit, filed this case 73 of 2017 under order 9/13 CPC, read with the section 151 CPC for setting aside the ex parte order dated 9/12/2016, passed by the learned Civil Judge number 1, Kachar Silchar, in miss appeal number 7 of 2013. Along with the said application, this case 74 of 2017 was also filed under section 5 of the Limitation Act for condemnation of delay. While the proceedings of this case 73 of 2017 was posted for cross-examination of PW1 by order dated 22/1/2021. No, not required. Last time. In the meanwhile, the proceedings of miss case number 74 of 2017 under section 5 of the Limited Act were dismissed by order dated 24/7/2023. And consequently, the proceedings of miss case number 73 of 2017 was also dismissed. They said on two orders dated 24/7/2023 passed by the learned Civil Judge number 1, Kachar Silchar, in miss case number 73 of 2017 and miss case 24 of 2017 are assailed in this revision under section 113 115 CPC. Next, in course of submissions, the Learned Senior Counsel for the petitioner has submitted that in the proceedings of miss appeal number 7 of 2013, where no notice was served to the petitioner and the proceedings of the said appeal was taken up ex parte, the application under orders 9/13 CPC, read with section 151 CPC, was otherwise not maintainable, as the said application was envisaged only for the purpose of setting aside an ex parte decree in the suit. Nonetheless, it is submitted that there are certain observations in the said order which could be read adverse to the interest of the petitioner, and therefore the said order is challenged. It is also submitted that the stand of the petitioner is that she intends to assail the order dated 9/12/2016 by which this appeal number 7 of 2016 was decided ex parte. After some deliberation, the learned senior counsel for the petitioner has submitted that is the proceedings of order 9 to 13 CPC was without jurisdiction, comma. The Indian order dated 24/7/2023 would also be known as in the eye of law. And accordingly, it is submitted that the petitioner will be permitted to withdraw the said application. And the present revision with liberty to approach the court again if so advised to rescind the order dated 24/7/2023 next. Apparently, it appears that an order under an application under order 9 to 13 read with 151 CPC, section 151 CPC is not the appropriate remedy to set aside the appellate order passed in exercise of jurisdiction under order 43 rule 1K, right?
Hello.
1K
It came.
CPC. Therefore, the court is inclined to allow the prayer made by the learned senior counsel for the petitioner, and this present revision stands closed on withdrawal with liberty to the petitioner to approach the Court of Learned Civil Judge number 1, Kachar Silchar, in an appropriate jurisdiction. If the petitioner is aggrieved, with the petitioner, who is the substituted legal representative of the original defendant 1, is aggrieved by the order dated 9/12/2016, passed 2 orders dated so and so passed in the proceedings of Miss Case number 73 of 2016 and no 73 of 2013. This Miss Case is 17.
This case is
17. 74 of 73 of 2017 and 74 of 2017.
yes.
With further liberty to approach the court again with the petitioner intends to assail the order dated 24/7/2023. No, that would be different. That would be appeal number 7 of 2016.
7 years.
7 of
Violation
2016.
7 to 13.
7 of
2013.
13, right. This is 7 of 2013. With further liberty to the petitioner to assail the order dated, the 2 orders dated 24/7/2023, passed in this case 73 of 2017, 74 of 2017 by the learned by the London signature in so and so. Okay, so both liberty you have to present.
The order was passed, initial order. The appeal was filed under order 43, rule 1 R, same.
1R.
R mentions order under rule 1, rule 2, 2A and 4, and also 10 of order 39.
Rule 1R. Okay. It'll take me some time to come back.
And in the appeal, when this appeal was preferred, they say they prayed for exemption of service of notice under order 41.
That could not have been allowed.
Hello?
That could not have been allowed.
Yes. So, so notice was immediately not served on us.
Just
Mentioned it, clearly mentioned in page 96.
I'm taking up after 2019. So it will take me some time to come back.
Yes. Forty-one 14 sub rule 4.
But was the notice not served on the lawyer also?
No, it is mentioned here. Page 96 is mentioned.
Page
96. According to them, notice was page 96, fourth paragraph. In Miss Appeal number 7 of 16, the petitioner cited filed petition under order 41 rule 14.4, praying for exemption of service of summons upon the respondent. The prayer was allowed by the learned predecessor and Miss Appeal was allowed on so and so on contest. This is the problem. Appeal was allowed admittedly without issuing notice, and it is mentioned it is on contest.
Sure, where we are referring to this Miss Appeal 7. Where there is reference to Miss Appeal 7 of 2016. No, sorry, Miss Case 73 and 74 of 2017. There you add. In connection with the proceedings of Miss Case number 74 of 2017, the Learned Senior Counsel for the petitioner has referred to the order, impugn order dated 24/7/2023, and has referred to para 4 of internal page 6 of the order within bracket page 96, running page 96, very close. And it is submitted that the learned civil judge number 1, Kachar Silchar, had recorded in the said order as follows, in inverted commas. In the Miss Appeal number 7 of 2006, that will find it page 96, blue pencil. Next, in the said context, it is submitted that as per instructions received by him, no notice of the proceedings of Miss Appeal number 7 of 2016 was served on the petitioner. And by referring to the provisions of clause explanation C of Rule 4 of Order 3 CPC, it is submitted that although the counsel on record in the suit continues, is deemed to have continued in the appellate proceedings by the said provision, but no notice was also served on the counsel for the appellate. The petitioner and of the predecessor of the petitioner.
Since your lordship has written that, also I'm just pointing out in the appellate order, while the order was passed in my absence and a notice was not served, still it was written on contest.
Okay. And it is submitted that despite proceeding ex parte against the present petitioner, the text of the impugned order dated 24/7/2020 would reflect as if the said appeal were disposed of on contest.
It is mentioned in the 9/12/2016 order by which I am agreed. Appellate order.
Okay. Which is mention of which is made in the order dated 9/12/2016, passed in the proceedings of Miss Appeal number
Miss Appeal number 7 of 2016.
7 of 2016.
Yes.
Okay.
Technically, there is nothing in the appeal, but the observations are there that violation is proved. That is the
So you see the beauty of proceedings that at times proceedings can be a lawyer's paradise.
deeply up.
I
It took us a lot of time, Mr. Mazumdar. Because from the synopsis, I could not gather anything.
I'm sorry, my because
No, otherwise also it's so clumsy that
that is
maybe
why I
perhaps.
prepared a small list of this.
Huh?
That is why I prepared a list of this.
Yes,
Yeah, please, Your Lordship.
Mr. Chaudhary.
This is a revision petition filed against the judgment and order dated 16/9/2019 passed by the learned civil judge number 1 in Miss Appeal, dismissing the Miss Appeal under order 43 rule 1K
Okay, that's fine.
against the order
Okay, I'm issuing a notice.
passed by the
Okay. Heard. Mr. P. Chaudhary, counsel for the petitioner. This revision under section 115 CPC is preferred against the order dated 16/9/2019. Just now. Where is the order?
yes at page annexer 27
Page, give me the page number.
188.
188. How you explain the delay? 2019 order you are challenging now.
Your Lordship, it was filed, it was in the itself in the year December 2019, it was filed, it was in the defective. So recently the said defect was corrected. It has been numbered. The seal has been put before the appeal member. So Lordship, there is also lockdown regarding during that period also, so it could not be corrected also. Recently, the
No, but we can't extend it like that. You can't keep it, keep a matter pending for 4 years in defect and then raise this, renew this appeal now. You'll have to file an application to explain the delay. This is something we'll not allow. In fact, we'll have to refer this matter to the rule committee to amend our rules. Our defective filing, we'll have to now make a rules that after 7 days, it will be wiped off of the filing section. You can't keep it pending for 5 years and then come 4 5 years, 19 to 23, 4 years. After 4 years, we can't commit you. But this P. Chaudhary counsel for the petitioners. Next one. This revision under section 115 CPC is preferred against the order dated 16/9/2019 passed by the London Civil Judge number 1, Kabul Metro Guwahati in Miss Appeal number 29 of 2011, which was filed under order 43 rule 1 within the KCPC. First off, on a query of the court, the London counsel for the petitioner has submitted that this revision was filed on 16/12/2019, but there was some defect and the defect was removed. On 21/9/2023, and thereafter the matter has been listed. Next paragraph. Having noted that the defects were removed about after about 2 years, 7 months. 2 years, 9 months. And taking into note that the period of limitation to file revision under 115 CPC is 90 days. The petitioner would be required to file an application for condemnation of delay to explain the reasons for the delay in rectifying the defects. This said direction is issued for the reason that it is impermissible to have a matter kept in a defective list for about 3 years, for 4 years, 3 years, 9 months, and not 2 years, for 2 years, 9 months, and then to seal the otherwise time barred order. This one. The court also reserves its right to request the registry to revisit the rules relating to applications kept defective in the filing section at an appropriate moment, appropriate time. How much time?
3 weeks.
3 weeks. You're not saying anything. You just say it will be listed when the condemnation application is listed. List this matter along with the application for condemnation delay is so filed. We'll be visiting that rules, our filing section rules. Well, it can't be permitted. Time barred application Because otherwise time bad. But you still file an application because it is, I'll move on the administrative side.
6.
Yes. You please button down your coat. Button up your coat. Don't keep it open. Yes, Mr. Jain.
My lord, in terms of order dated 28/6/23, the petitioner
But
was
what is the error in this order? You want extension of time to file counterclaim.
my lord,
Your counterclaim is like a suit.
yes, my lord. On 11/4/23, my lord, the petitioner was directed to file counterclaim. And on
No,
11/4
counterclaim is, Mr. Jain, counterclaim is a suit.
yes, ma'am.
So in suit, you can't have a limitation extended. So what is wrong in the order?
My lord,
There can't be an extension or limitation to file a suit.
yes, ma'am. My lord, that was the date was fixed on to file counterclaim
No,
on
you
11/4/23. my lord.
what is the law in counterclaim? When does the right to accrue counterclaim, when does the right accrues for filing a counterclaim?
My lord, that was explained, my lord, in the counterclaim itself, my lord, when the petition was filed, seeking leave of the court to file counterclaim, my lord, and that leave was granted, my lord, by the learned court below, and accordingly, the date was fixed on 11/4/23 for filing the counterclaim
Shows
without
any
fail, my
settled law on the point of filing of counterclaim. A limitation can't be extended, so far as I understand, subject to how you convince me.
my lord.
Counterclaim must be filed along with the written statement.
Yes, ma'am.
You can't be given extra time to file a counterclaim.
Even after filing the written statement, the learned trial court may grant the leave for filing the counterclaim
That is
accordingly.
without jurisdiction. That would be without jurisdiction. Even if you have given a leave and you don't apply on that day, you don't file a counterclaim on that day,
My
you know,
lord,
right goes.
by the Annexure C, my lord, we had filed a petition wherein it has been clearly mentioned that there is a cause of action is arising after filing the written statement, my lord. And accordingly, we had filed a petition and the court has granted to file.
Where is
the
your counterclaim?
My lord, page number 43, Annexure C, my lord.
43.
Annexure C, my lord. That the above noted suit stand posted for
Where is the High Court order?
my lord, High Court order, my lord.
CRP 29.
On 3/2/23, my lord, the Honorable High Court has passed this order to file the written statement, my lord. Accordingly, on subsequent date, my lord, on 4/2/23, the High Court's order was on 3/2/23, my lord.
You have a copy of that order?
3/2/23.
Pass it on.
My lord, in while order dated 3/2/23 in this revision was disposed of, my lord, in CRP 29/23, my lord. Here, my lord, the present petition is filed for setting aside the order dated such and such passed by the landed civil judge in title suit number such and such, whereby the prayer of the petitioner here in defendant number 1 is to submit written statement was rejected on the ground that the period of 90 days in filing the written statement prescribed under proviso to order 8 rule 1 of the CPC was over. The learned counsel for the petitioner submit that on 13/12/2022, the defendant number was ready with his written statement. However, the same was not accepted. As the petitioner has already prepared the written statement and same is ready, if the same is allowed to be filed, the plaintiff will not be prejudiced in as much as on the next date of the suit is fixed for SVPS on 4/2/23. In that view of the matter, the present revision petition is allowed, directing the defendant number 1 to file the written statement tomorrow, the 4/2/23, before the landed trial court. Below, on such filing of the written statement, the landed court below shall accept the same and proceed. In the result, however, if such written is not filed, tomorrow the landed trial court below shall proceed for SVPS. In the above terms, the revision petition is disposed of. My lord, according terms of that order, written statement was filed on 4/2/23, my lord, and thereafter, my lord, on the date we had filed a petition praying for filing counter claim in addition to the written statement, my lord, that was allowed by the learned trial court, and accordingly it order dated 4/2/23. This is the order, my lord, and at previous date, actually, my lord, on 4/2/23, in the revision petition, we have annexed the order downloaded from e-court services, man. That was only the operative portion, man. Hence, this honorable court was pleased to direct the petitioner to file the detailed order, and we have obtained the certified copy, my lord. And today we have filed that to place on record the order dated 4/2/23, my lord, by way of additional affidavit.
Just a moment. What is that, Mr. Decca? What is that judgment? What Ardavatia about counterclaim? What is that judgment?
Which
Or order 8/2/6, that Ardavatia. First name I forgot.
Bolponde. Bolponde.
Huh?
Bolponde. There's one called Bolponde.
No. So Ardavatia. ARDHWATIA.
I'll just check.
Tomorrow is the date fixed in the trial court, my lord.
These issues have been framed, no.
Not yet.
Ramesh Chand Ardwatia, Anil Panjwani. Ramesh Chand Ardwatia, Anil Panjwani. 2003. Yes, sir. You see, there are judgments of the Supreme Court which has permitted. I forgot the citations now. Some judgment of Kalra, KLRA. That is a judgment where the Supreme Court has said that even subsequently a counterclaim can be filed, if assuming that there is a cause of action. But in that judgment, the case of this Ramesh Chan Ardwatia was not considered. In this Ramesh Chan Ardwatia, the Supreme Court has said that cause of action for filing of the counterclaim must be from the filing of the written statement. It must, rather, it has stated that it must be a part of the written statement. And this is an authority on the point that even this and Kalra I was not getting right now. The Kalra case also says that independent of the counterclaim, if there is a subsequent cause of action, you will not be prejudiced if you file your own suit. So therefore, you will have to come out of it. Last page, Anivana. Yes. Ashok Kumar Kalra, yes. Yes.
Ashok Kumar Kalra versus Wing Commander Surendra Agnihotri.
Wing Commander, yes. So what is the citation?
Citation, my lord, I have not. That is SLP civil number 23599 of 2018.
Ashok Kumar Kalra. I'll just get it. Thank you.
I'll just get the citation.
No, it's okay. Now I'll get it. That is the judgment where Mr. Chaudhary said that counterclaim can be filed assuming that there is a cause of action subsequent to the suit.
Yes.
But in that case, Ramesh Chan Ardwatia was not considered.
Not considered. Because Ramesh Chan Ardwatia basically is, my lord, that my lord, by force you cannot dispose anything, anybody. And
No,
my
no,
lord,
no. This I don't know the facts. Ramesh Chan Ardwatia is what happened was the counterclaim was sought to be introduced by way of an amendment.
My lord.
And that the court said no, it must find place along with the statement. And by amendment, counterclaim cannot be introduced. And then there is because there are certain things. Yes, what is your stand in the meanwhile? Till you get the judgment.
Firstly, my lord, I'm not on caveat, my lord, so I don't have a copy of the application.
Okay.
Now, my lord, otherwise, my lord, one thing, if your lordship permits me, if I may point out, my lord, has been an earlier round of civil revision proceedings, my lord. They missed out on the limitation to file a written statement, my lord. Against that, my lord, they approached. There we conceded, my lord, that let them file the written statement. Next day, they filed the written statement and they say this is only half the written statement, we'll file the counterclaim again later. They are accommodated another day, my lord. And then thereafter, my lord, it is closed. Now, firstly, the conduct, and secondly, my lord, for file, where is the question of seeking a date for seeking a permission to file a counterclaim? My lord? If they file it, then the court would have examined, my lord, whether it is permissible. They wanted to halt the proceedings, saying that we'll file the counterclaim in future.
If you have a cause of action which is after that, after the suit is filed, then you can file an independent suit. You will not be prejudiced. Mr. Chaudhary, we have got it. 2020, Volume 2, SEC 394. Para 20. So this is by a 3-judge bench.
Yes,
Ramesh
this
and
is by-
Advati was considered.
Well, the other judgment also otherwise says that there's a discretion it can permit, although it says that it must find place in the written statement.
Okay, 20. 20. This one at the top. Go ahead. Ah, 21 here. 21. You see, this is what it says.
Yes.
The sum of filings, this is a 3-judge bench order. The sum of findings that order 6 does not put an after filing the restriction other restriction of the actual of cause of action. Having said it does not give absolute right to be defended by counterclaim with substantive delay, even if limitation period prepared not elapsed. The court has to take into consideration the outer limit for filing of counterclaim, which is pegged till the issues are framed. The court in such cases have discretion to entertain filing of the counterclaim after taking into consideration evaluating inclusive factors which are not only illustrative. So, in that view of the matter, we provide that this order shall not come in the way when the counterclaim is filed to evaluate.
And the court will see whether
It's a limitation or there's a different cause of action.
Take into account those. So this order basically was only refusing to adjourn the matter on the ground that they will file. had they filed it, Manu, the court would have examined whether it conforms with 6A or not.
But Mr. B.K. Jain, counsel for the petitioner, as well as Mr. B.D. Dekha, counsel who holds brief for the respondent before the trial court. However, he has not filed a caveat. Next paragraph. By this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 11/4/2023, passed by the London Civil Judge number 3, Kamrup Metro, Guwahati, in TS 413 of 2022, thereby rejecting prayer made by petition number 1991 of 2023 dated 11/4/2023, thereby rejecting the prayer of the petitioner, who is the defendant number 1 in the said suit, for granting extension of time for 1 week to file counterclaim. Next paragraph. The learned counsel for the petitioner has referred to the contents of petition filed before the Learned Trial Court on 4/2/2023 to project that the time was sought for, time was paid for filing of counterclaim, and it has been mentioned in the said petition that the cause of action for the counterclaim has also arisen before filing of the written statement. First, it is submitted that on 11/4/2023, prayer for adjournment was made as the defendant number 1 was suffering from various ailments for which she was undergoing treatment under the care and supervision of a doctor, who had advised the defendant number 1, petitioner or the defendant number 1, to take complete rest for a week. Full stop. It would be appropriate to refer to paragraph 21 of the case of Ashok Kumar Kala, KLRA versus Wing Commander Surendra Agnihotri, SURENDRA, AGNHOTRI, and others, 2020 within bracket 2020, 2 SCC 394, when a 3-judge bench of the Supreme Court of India, after considering various authorities on the issue of counterclaim, had summarized its finding as under. Page 21 is reported. Full stop. Next paragraph. In view of above, and on considering the fact that the petitioner in this case had paid before the learned court for extension of time to file counterclaim. Stop. The in the opinion of the court, comma, the court would not have power. The trial court would not have power to extend the time for filing of counterclaim as the cause of action for the counterclaim is normally relatable to the filing of written statement. Full stop. Next one. In the case of Ashok Kumar Kalra, the Supreme Court of India has laid down that the provisions of Order 8 is Roman 8, Rule 6, capital A, without bracket, no bracket, 6A. CPC does not put an embargo on filing of the counterclaim after filing of the written statement by further holding that the restriction is only with respect to the accrual of cause of action. And it is also clarified that the said provision does not give an absolute right to the defendant to file counterclaim with substantive delay. Poster. Next, accordingly, comma. Insofar as the Impune order dated 11/4/2023 is concerned, comma, court does not find any jurisdictional error committed by the learned trial court to refuse extension of time to file written statement. Next, nonetheless, comma, be that as it may, in view of the law laid down by the Supreme Court of India in the case of Ashok Kumar Kalra within the Supra, comma, it is only when a counterclaim is presented before the learned trial court, court would have the discretion to entertain the filing of the counterclaim after taking into consideration and evaluating the factors as laid down in paragraph 21 of the said judgment, which is already quoted herein before. So just come below, Mr. Das. Just come below. About 7 paragraphs below. 7 paragraphs below. 27, 20. Okay. Just okay. it would also be relevant to quote paragraph 31. And last paragraph. 31, and last paragraph. Last paragraph. Last paragraph. And 60. 60. These two paragraphs. Just two. Next paragraph. Next paragraph. In view of the discussions above and considering the law laid down in the case of Ashok Kumar Kalra within the Supra, while not entertaining the challenge to the impugn order dated 11/4/2023, passed by the learned Civil Judge number 3, Kamrup Metro Guwahati in TS number 413 of 2022, the court is inclined to provide that if counterclaim, if any, is filed by the petitioner, the same shall be considered in terms of the ratio laid down in the said case of Ashok Kumar Kalra within the Supra. This revision petition stands disposed of in the motion stage without issuing of notice on the respondent. Just one paragraph to let you. After submission of Mr. Jain, right, that, so BD Rekha counsel for the respondent submitted that there was an inordinate delay in filing of the written statement for which the right of the petitioner to file written statement was closed. However, this court by order dated 3/2/2023 passed in CRP IO 29 of 2023 allowed the petitioner to file his written statement. Accordingly, they submitted that the counterclaim ought to have been filed when the written statement was filed. Just in that statement. Okay. We're permitting you to file it, but it will be subject to scrutiny by the trial court in light of Ashok Kumar Kalra.
Okay.
The present challenge is not maintained.
Seven.
Yes, Mr. Chaudhary,
That is the lordship, my lord.
how your challenge would be maintainable?
The challenge will be maintainable, my lord, because of the fact that, my lord, the question that will arise from, my lord, consideration of this honorable court will be whether, my lord, a person, my lord, third party who is not a party to the suit will be entitled to maintain a petition under Order 21, Rule 97. And, my lord, now going by the, my lord, law that has been settled, that even if, my lord, it's a third party, the challenge ought to have been under Rule 101. Now, my lord, if it is 101 and, my lord, it says misquoted as 1997, there is no issues on that, my lord, because when there is a power of the court, my lord, then that power can be, my lord, exercised. But, my lord, while, my lord, adjudicating upon the petition, my lord, under Rule 101, what has to be set up by the third party is a right, my lord, and a right, title, and interest, which goes conversely to the right, title, and interest which has been decreed, my lord, and then, my lord, the execution of the decree can be stalled. And here, if your lordship finally sees the petition which has been filed, they have stated that, my lord, the decree which has been passed, my lord, has been erroneously passed, my lord. Has been erroneously passed, and, my lord, some fraud was played on the court, my lord, on the basis of which the decree
No,
was passed.
you see, if I have understood you correctly,
My
in
lord.
this petition,
My lord,
you are the plaintiff.
I am the plaintiff.
You got a decree,
My God,
and that decree was put to was assailed by the third party.
my lord,
Correct.
my lord,
Now, during the pendency of that application,
my lord.
it is their case that you have forcibly taken over possession of the land,
Yes.
and
No, their case is, my lord, when the execution was, my lord, objected to by this petition in the year 2016, then there was a, my lord, order which stayed the execution of the decree. The executing court stayed the, my lord, execution proceedings, my lord. And, my lord, thereafter, that is why I said, my lord, even though the petition is numbered as, my lord, under Rule 97, it has to be construed to be one under Rule 101,
no, whatever be.
my lord.
But you see,
But
ultimately, when you took over possession of the land,
My lord.
it was not by way of a decree, execution of a decree. You just entered into the land with muscle power.
No, that is not the case. That they have raised later on, because kindly see, my lord.
So where is the
Of-
order of execution? Where is the warrant issued to give you possession? That I am not finding
No,
here.
I am already, no, my lord, because I was already in possession, because, my lord, when
No,
lordship,
if you are in possession,
to confirm my
why-
possession by way of the execution, this execution case has been initiated, my lord.
but for confirmation of possession, there is no execution required.
My lord, execution is not required, my lord, perhaps they thought it prudent, my lord, that they were there already, but if the decree is executed, then it
No,
will
no, no,
confirm,
no,
my lord.
no, no,
So on one
No.
fine day, my lord, a petition was
no,
filed
no,
under
no. You see,
151.
where is your judgment and decree?
The judgment and decree is not on record, my lord. It's there. My lord, judgment is at, my lord, page 43.
43 is a what do you
29.
call is a
No, ma, 29.
compromise petition.
29.
29. This is a compromise.
Yes, my lord.
So the
Compromise.
compromise petition
Yes.
is a part of decree.
Yes, my lord.
There is no question of any execution. How can an execution be pending? Why is the requirement of execution and why stay? This merely says both sides present filed an affidavit of compromise in terms of that
My lord.
compromise decree.
My lord.
Now in compromise decree, how there can be an execution?
Whatever it is, an execution proceeding was there, my lord.
But
Now-
it can't be. It's a settlement outside the court. That's
My
why
lord.
you see the documents. What you call has to be read.
My lord.
Whatever the respondent has submitted before the court,
My
it
lord.
said that you forcibly took possession of the land.
That is in the petition under 151.
No, 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 no.
Because initially, my
No,
lord.
no, no, no. I'll tell you.
My lord. At page 30, Lordships find that petition, my lord, which was filed for objecting to the decree, my lord, execution. 30.
Where is the copy of execution petition? Do you have that?
I don't have it right now. My lord, I don't have that execution petition. But I have the decree, my lord.
Show me that. You see this? Has to be. Well, otherwise it doesn't make sense. You see, what does your compromise petition say in paragraph 5? It says that unless you execute the sale deed and give delivery of possession within 15 days, you will have a right to file execution.
Yes.
Therefore, we'll have to presume that your possession was not granted and sale deed was not executed.
My lord. Sale deed. Sale deed was executed. Because the objection which has come is not from the defendants.
No. You see, I am only reading part of it. I'm
My lord.
not aware of the full facts.
My lord.
Here, paragraph 5 says the cause of action which will permit you to file an execution petition. It arises when? Number one, when sale deed is not executed and possession is not given.
My lord.
Only then.
My lord.
And it's a compromise. You see, you
My
can't file execution for any other purpose.
My lord.
So therefore, we'll have to presume that the sale deed was not executed and the possession was not given. That was execution. You will take it up after 1 or 2 days. You file better particulars because this is we are not convinced. When?
1 week.
After the week.
First week of October.
Okay. Based on 4/10/2023 as paid for by Mr. G. Chaudhary, counsel for the petition. Otherwise, it doesn't make sense.
I understand, my lord, but I can only try, my lord. Because today, just while entering the courtroom, my lord, I saw that even the fans were in dock, my lord. I thought his fans were also in the dock, my lord. So I thought, so my lord, I was correcting myself over and over again.
Because we can take cognizance of unnecessary sound coming from there.
But
That's why it's put under
the dock, my lord.
not on the dock, safe custody.
Safe custody.
Yes.
Also, I filed an application for impleadment and my application has been rejected. Lordship, respondent number 1 has filed a suit against respondent number 2 to 6. claiming declaration of right title interest in respect of property, as well as that the sale deed executed by respondent 2 to 6 is binding on them.
Where is the impugned order?
Lordship, it is at page 41.
One.
Page 41. The third party petitioners of this instant petition have submitted that they, along with the present defendants, have inherited the instant suit land, and as such, having interest in the same, they are necessary party in this instant suit and have therefore paid for impleading them as party to the suit.
But that would not be sufficient to have you impeded. Anybody cannot come in a suit and join as a defendant.
No,
You
Lordship,
have to show your right.
Lordship,
Your
the
right
suit-
is not even pleaded.
Lordship will produce page 13.
Page
13. It is a
13.
Plaint which has been filed by the plaintiff, paragraph 2, Lordship.
Yes.
That on death of the said Mr. Muhammad Diwan Ali, the land of Schedule A jointly inherited by the defendants as his legal heirs and successors, and they become title holders of the land. The land is the subject matter of the suit hereinafter referred as the suit land. So the plaintiff himself says that the land devolved upon the defendants from their common ancestor, who is the father of the petitioners also. So when I have not been arrayed as a party and I am an owner along with the defendants, I ought to have been impleaded, Lordship. Again, the defendants
No.
have also admitted the said position, Lordship.
No, you see, come to page 33.
33. Lordship.
You see paragraph 2, there is a stand of the objectors.
Lordship.
The suit is self-acquired property of the plaintiff purchased on so-and-so.
Lordship.
Present and the duly mutated. Intervenants have no legal right. So therefore, your names are never mutated in the record of rights.
But Lordship, though it was not mutated, since I am the daughter of the common predecessor, so I will be having a right in the suit line.
No, that would have expired. You see, you have Transfer of Property Act with you. See section 3 or 5, I forgot. It's a notice. Interpretation clause. See notice. Either 3 or 5. 3.
A person is said to have notice of a fact when he actually knows that fact, or when, but for willful abstention from an inquiry or search which he ought to have made, or gross negligence, he would have known it.
So you see, 97 the sale deed was made,
Lordship.
and so therefore your last title would have lapsed from the date when adverse position Article 65 takes into effect.
Until and unless, Lordship, the nature and character of the suit land is not changed, how can I come to know about the said sale
That's
deed?
what I said. You see, for natural, this has to be there, and once you see the Registration Act, that's also notice. You see, provided that the instrument has been registered and its registration completed in so and so. So even if sale deed is registered, owner is deemed to have notice. Same down below.
Lordship.
Person is said to have notice.
Lordship.
Explanation 1, then provided.
Lordship, but until and unless there is some change on the spot, I cannot be, it is there, Lordship. There is no dispute to that. But Lordship, until and unless there is some change in the nature, how I can be aware of the said fact, Lordship? Now,
No, that
as
is
soon
only,
as I
you see,
have
you
come to
must
know
have,
about
no,
the
no.
suit, Lordship,
You see, if you are the owner, you would have asserted your right at some point of time over the land. So it's that assertion of right would have influenced the right of the purchaser, but that right was never exercised. You see, subject to how you convince me, number 1, owner of the property or a joint owner of the property may exercise the right of possession on behalf of others. I've got no difficulty in understanding that.
Lordship.
But if it has been sold for the purpose of sale,
Lordship.
there must be some entry in the Jamabandi to show that this land after the death of the predecessor interest was mutated in the name. Otherwise, sale permissions would not be given. So have you, do you have a copy of Jamabandi showing that your name was entered there?
Lordship, in my humble submission, all the facts or laws stated by Lordship that might be relevant at the purpose of deciding the suit, but for inclement Lordship, I should be given a chance to.
No.
contest it.
You just can't impede yourself in any suit without any without showing any cause of
More particularly, Lordship, when plaintiff himself states that the defendants originates from Diwan Ali, defendants themselves state that I am their brother, sisters, and granddaughters of the same person.
You file your own suit to assert your right. Why you want to be implicated in the defendant and change the contour of the suit? If you have any right, title, and interest, you have to assert it yourself.
I can file a counterclaim in this suit itself. Lordship.
No, that will be independent of the cause of action of the plaintiff's case. You can't be permitted that.
In that case, Lordship, perhaps Mr. Ali was supposed to argue this case today. He is not well today. So if Lordship may grant some time to me.
Okay. Next week, list on the in the next week, is paid for by Mr. D. Saraf, counsel for the petitioner. Okay.
All right, Lordship.
Please, Your Lordship, conducting counsel MS SSGI is not available today.
Pardon me?
My lord, SSGI conducting counsel, she is not well, Lordship. I just received the phone.
But tell me two things. Number one, you have a copy of the brief? No.
I don't.
Mr.
S. Gautam, Your Lordship.
S.
Gautam.
Gotham Council for the Learned Council has submitted that is SSGR, Learned Council for the petitioner is unwell and therefore prays for adjournment. Prayer for adjournment is allowed. Next paragraph. It is noted that this court by order dated 31/5/2023 accepted the had accepted the affidavit filed by the petitioner on 27/10/2022 to be refusal of service of notice by way of Dasti. Full stop. On a perusal of the said affidavit, copy of plaint annexed to this application to this revision, as well as the cost title of this revision, two things is noted. Number one, in the plaint, the name of village is name of village of the respondent plaintiff is mentioned as Burhadai, Burhadai. However, comma, in the cost title of this revision, comma, the name of village is mentioned as Burhadai, Burhadai, Chapara, Chapara. Therefore, the counsel for the petitioner shall have to inform as to whether these two villages are one and same. Next para. It is also noted from the said affidavit filed on 27/10/2022 that although the notice contains two signatures, comma, purportedly of witnesses, comma, but there is no note appended by the said witnesses or by the petitioner that in their presence the respondent had refused to accept a service of summons, notice of the court. The said aspect shall also be addressed by the court of the by the learned counsel to the petitioner on the next date. Next part, list after
1 week. 1 week.
list after a week.
But if there is an interim also.
Okay. Interim order passed against and is extended to the next week of listing. You tell her to download the order and then look at it, because this service report may not be acceptable. We'll take a break and come back.
Thank you.
Page
Page 156 of the IA. The document on the document by which I had filed the completion certificate, applied for the occupancy. Madam. Let me just hand over. Contents are the same. Madam. At the bottom, the seal is appearing. The date is not in dispute.
What is the date?
Date is at the bottom, Madam. The seal 3/7/2018.
3/7/2018.
So, Madam, if I can give a factual the background of the facts, Madam, for your lordships to better appreciate. Madam.
Where is the order first?
The impugn order, Madam. It starts at 408, Madam.
408 of this IA.
Of the IA. And the respondents herein, Madam, they had taken a villa in a construction which we have made, Madam, the appellant before your lordship. So dispute, Madam, just to give a factual background, Madam, we are an owner of a plot of land measuring total at 30 bighas approximately. We had carried out the construction in two phases. Phase 1 was supposed to be over a plot of land measuring 23 bighas. 23 bighas and odd, Madam. 5 bighas is the phase 2. That is complete. No dispute with regard to that phase. Now, this phase 1 was supposed to be constructed over that plot of land measuring 23 bighas. This is covered by the GMD.
This 5 bigha is under the Gaon Panchayat. And there is another additional plot of land measuring 2 bighas, which is also under the Gaon Panchayat. At that point in time, it was the Gaon Panchayat. Now it is the municipal board, not Guwahati municipal. Now the villas are basically constructed over the plot of land measuring 23 bighas. In that 2 bighas, we were supposed to construct a clubhouse with a swimming pool. Now what has happened during construction, some part has entered into the plot of 23 bighas, for which the GMDA has held that there is a deviation. I'll come to that. Now, Lordship has seen on 3/7/2018, we applied for occupancy. Now, the first inspection is made. The first order of rejection comes in March 2021, 23/2021. I'll take your Lordship to that document, my lord. It is at page 150, 158, my lord.
You applied
Not
when?
158, 157.
You applied when?
On 3/7/2018. Although, my lord, I am not pressing that deeming provision under the bylaws, because that requires that the construction should be made exactly as per the sanction plan. But there is admittedly that is minor deviations here and there. I'll point that out to your lordships. But they are required to make an inspection as early as possible. Now the first rejection comes at page 157. From July, my lord, 18, 19, 20, 21, almost 3 years.
What is the date?
Date is 23/2021.
Yes.
So here, my lord, the deviations which are there, my lord. Number one, the area in the site plan approved as triangular garden wing so-and-so at the main entrance has been obstructed by constructing a brick wall. This has been rectified in the meantime. Number two, structures like the clubhouse, swimming pool, caretaker house, and security barrack are erected at the designated area for children park without any approval from GMP. Now, with regard to this, my lord, the caretaker house and security barrack, these have been now regular. In fact, there was no deviation because total 124 villas were allotted. We have constructed 123. This security barrack was in the place of a villa. Now GMD has not gone into that aspect. Deviation is the clubhouse and the swimming pool. That is admittedly that is there. Now, if your lordship sees the next page, 158. Because why I am drawing your lordship's attention to this, because one of the main contentions and the bone of contention is the occupancy certificate. Because I have been penalized on 3 counts for not having the occupancy certificate, and how the respondent himself, he is preventing the getting of the occupancy certificate. That I want to demonstrate to your lordship. Lordship sees the 3rd paragraph, whereas GMD has served notice to so-and-so by letter number 23, which I have just now shown, my lord. Now these are the deviations found. It is a replication of that letter, my lord. Now what is the order, my lord? The undersigned examined the documents and facts placed before him, and the following directions are issued for further consideration of the OC. Open area, that is children park, is to be provided as per the area earmarked in approved plan and allowed to be relocated. So the GMDA permits that whatever area is there, it is allowed to be relocated because it's a children play area, my lord. Whether it is here, for the GMDA, it is not a matter of concern, my lord. Now the rest may not be relevant, my lord, because now we are only on that children park. The triangular garden that we have already done. Point number 2 we have done. Consent from 2/3 purchaser of flat is required to be furnished. Here the RIAT itself has held that this is not required. A clearance report from North Guwahati Municipal Court, this has been done, my lord. Registration particular, this is done. Updated and corrected completion drawing, this has been furnished. Next hearing within 2 months. Now lordship will kindly turn to the next page. This order is passed, my lord, without hearing me. Now lordship will just come to the first paragraph. In pursuance to the order that a number so-and-so in connection with occupancy certificate of proposal of so-and-so, the undersigned heard Mr. Ganesh Das, who is the respondent number 1, an advocate, and see so-and-so representatives of so-and-so on 21 in presence of so-and-so, so-and-so, so-and-so. So, my lord, without hearing me, the respondent is heard. And the observations are here, Children Park now, the triangular garden is earmarked in this we have, my lordship need not go into point number 1. Number 4, my lord. Children Park as per approved drawing is to be restored. So without hearing me, this order is passed. Now what I am on, my lord, whether I restore it, whether I relocate it, my lord, that's a matter between me and the GMD. My lord. The occupancy certificate is between me and the GMD. Now, what is this respondent number 1 doing in a matter of grant of occupancy certificate to me? Because he has filed numerous litigations against me, and the complaint filed by him before the RERA is non-obtaining the occupancy certificate. Because lordship sees the violation part, page 157, nothing in respect of the villa. 123 villas, the GMDA, after making a scrutiny, my lord, survey, they find nothing wrong with the villas. Only difficulty is that clubhouse has entered into the GMDA area. The swimming pool part has entered. Now that is not for my benefit. That is for the benefit of the residents. I do not gain anything. I have already made the constructions. Tomorrow, if the GMDA demolishes, or I am made to demolish that, my lord, nobody gains anything, my lord. And now entire 30 bighas of land is one complex where phase 1, phase 2, common facilities for both the residents. Now there is a subsequent development in the month of August, my lord, the occupancy certificate, part occupancy certificate has been granted to us. Now, because in December, the GMDA conducted an inspection, they found that there are numerous violations by the residents after taking possession. So those occupancy in respect of those villas have been withheld, but rest have been granted. So now going back to the case before the RERA, the respondents filed complaints under 9 heads: non-furnishing of documents, then violation of the sanction plans. Then number 3 is, my lord, the agreement is not in the format. Then possession which he was given, we asked for the possession. His contention is that the possession is not lawful possession. Why? Because the OC is not there, so the possession is not lawful. But he is occupying the house. There are photographs, my lord, is not disputed. He has made additional constructions. He has almost constructed a top floor, for which now the GMDA is not giving the occupancy certificate in respect of his villa. Then now he contends that the transformer load was more. Now it is less, so it is a deviation. So in respect of under 5 counts, we were penalized by the RERA. Now the RIAT has interfered with so far as the non-furnishing of documents is concerned. The RIAT has come to a finding that no, the documents were furnished. So the penalty has been removed, but we have been directed to once again give a copy. But we have no difficulty, we will do it. Now regarding non-adherence to sanction plans, I have to admit that there is a violation with regard to that now the swimming pool and clubhouse. But then agreement not in the prescribed format. Although I may argue, my lord, that it's a bilateral act, my lord, I admit that yes, it is not in the format. But the 2 main points, my lord, the possession and the transformer part, I'd like to address your lordships on that. Now, if your lordship kindly comes to page 43.
No, I'll not understand unless you show the order and then tell us.
Smart, my lord. Now, I've just given a background of the facts. Now, 408. We may skip the first 2 paragraphs, my lord. Paragraph 3. Facts briefly are that the respondents herein, namely so-and-so, had entered into an agreement for sale dated 27/8/2018 with the appellant herein, Mrs. So-and-so, a company so-and-so, to purchase a villa, particularly villa number so-and-so with built-up area of so-and-so and land area of so-and-so in the real estate project called Area so-and-so. In the project covering 19 bighas, 4 lechas, the cost of the villa was approximately so-and-so. The construction of the building was to be completed and handed over within 2 years from the date of execution of the agreement, meaning 27/8/2020. Lordship will kindly mark the date, madam. As per the aforesaid agreement, the registration of sale deed was to be take place after getting the requisite permission from the competent authority. The complainants paid 100% of the total sale consideration amount to the builder as on 31/10/2019. The builder had issued a possession certificate dated 28/11/2019 stating that he had handed over the apartment to the complainants. The builder had applied to GMDA for occupancy certificate on 3/7/2018 but had not yet received the same. In course of time, the respondents issued raised 9 numbers of complaints against the builder on various grounds before the RERA. The RERA recorded its finding in respect of each of the complaints and passed directions. Challenging the order, the builder filed the instant appeal before the RERA. For easy understanding, each complaint is being dealt with separately in the subsequent paragraphs. On complaint number 1, this is in my favor, my lord, so we may skip, my lord. I am not challenging this. We come to 410, my lord. In the middle portion, the finding is in my favor, my lord. Hence the findings of the RERA regarding violation of so-and-so is not sustainable. At page 410 in the middle portion. So I am not reading that, my lord. Complaint number 2, non-adherence to sanction plans and project specifications. The RERA has observed that the RTI reply furnished by the GMDA to the queries of the complainants respondents dated so-and-so show that the builder has made deliberate deviations in the construction of the project for which he has also not taken consent of 2/3 allottees of the project. Thereby, he has violated section so-and-so of the Act. Findings and orders of RERA. For ready reference, section 14(1) and 14(2) are reproduced here. I am not reading the provisions, my lord. 411 next part. The reply of GMDA, in short, GMDA contained in letter dated 17/3 in response to the RTI application dated so-and-so of so-and-so. Sumana Das is the response number 2, madam. Says that the correct application for the occupancy certificate had not been submitted by the builder till that date. In the subsequent reply of GMDA contained in letter number so-and-so in response to RTI application, see so-and-so and so-and-so, it shows that the occupancy certificate of replicas project was still under process. It nowhere mentions of any violation by the builder. However, in the letter number so-and-so, which I have read, placed before your lordship, it is indicated that the application for OC has been rejected on the following grounds. The above aspect shows that the builder had not adhered to the sanction plans approved by the GMDA. The appellant himself has stated that he has earmarked a total area of so-and-so more than the original area earmarked for the children park. He has further stated that as per the sanction plan, the area of the children park, though not specifically mentioned, is around 810 square meters. And after entering of the clubhouse into the portion of the same, the area is now around 663 square meters. He has also admitted that he has removed the brick wall around the area of the main entrance, which has been approved by the approved for constructing a triangular garden. For the deviations, the appellant was required to make previous consents of 2/3 of the allottees as enjoined in section so-and-so. But he did not do so. Hence, RERA's finding in regard is valid. However, RERA has ordered that all the deviations made by the company from the sanction plan as approved by the GMDA without obtaining the previous consent of the 2/3 of the allottees and without subsequent approval regularizing the GMDA be rectified immediately in compliance of 14(2) has also barred the GMDA from regularization of the deviations found in the execution of the project, if any, from the sanctions plans as approved by them, even if it is allowed under the relevant acts and rules without prior written consent of 2/3 of the allottees of the project. The said directions of RERA appear to be putting unnecessary fetters on the powers of the GMDA. Section 14 of the Act does not require the builder to remove a deviation which can be regularized by the competent body, simply because previous consent of the 2/3 of the allottees are not taken. In such cases, remedy lies in section 61 of the Act, which provides as follows. Then the finding is, this tribunal is of the opinion that imposition of suitable penalty was well within the power and jurisdiction of RERA, which was done for deviation from the sanction plans without obtaining prior approval of the 2/3. The GMDA is also permitted to proceed in the matter as per its acts and rules to deal appropriately with regard to any deviations of the part. So on the one hand, it is held that 2/3 is necessary. And in the same paragraph, it says that without the 2/3 also the GMDA can go ahead and rectify, regularize something which is otherwise permissible. Then deed of agreement, my lord, this finding, this is admittedly, it is not there. It is not in the format for which some penalty has been imposed, my lord. Although I may argue that it was a bilateral act, but ultimately it is not in format. Now, this is important. Complaint number 4. Inability of the respondent to give lawful possession to the complaint. RERA has stated that as per provisions of 11B of the Guwahati Building so and so in short the Building Act, the appellant is considered to have received the deemed occupancy after expiry of 21 days, provided the building has been constructed as per the approved plans. RTR replies that so and so and so and so, and the subsequent correspondence that so and so and so and so, addressed to the builder by the GMD indicates that the builder did not adhere to the sanction plan as approved by the GMD. Therefore, the presumption that the builder had received the deemed occupancy is misconceived. The RERA has also observed that the promoter cannot give possession of the apartment without receiving the occupancy certificate, as enjoined by clause 7.2 of the model form of so and so. RERA has concluded that in the instant case, the act of issuing a possession certificate to the complainant by letter dated 28/11 is in violation of section 11(4)(b) and 19(10) of the Act, read with clause 7.2 of the NHRA, prescribed under rule 9 of the rules. The builder is therefore liable to be penalized under 61 of the Act. RERA has ordered that the builder shall obtain OC from the GMD by complying with all directions issued to it by the GMD. Further, the builder shall hand over the authenticated copies of all relevant documents, namely the NOC issued by the competent authority, completion certificate, so and so, and hand over lawful possession of the villa to the respondent companies by completing all the required formalities as per provisions of law. RERA has also stated that the respondents' complainants are entitled to get interest from the builder at SBI's marginal lending rate of lending plus 2% on rupees 1.5 crore with effect from 28/8. This has been interpreted with me. But the finding is that the possession which I have handed over, my lord, is not lawful possession. So I am liable to be penalized. I am aggrieved by this. My basic contention here is, my lord, that the stand of the respondent is barred by the principles of appropriate and reprobate. On the one hand, he is asking for the possession. He takes over possession. He says that he does not have any grievance against me. He is enjoying the property. He is enjoying the benefits of the property. And again, he is challenging that my possession is not lawful. And my lord, the learned Riep, my lord, has not even discussed the judgments on which I had placed reliance. Only one judgment is referred to. I have placed other judgments also that is not even referred to, my lord. The finding starts in page 415, my lord. Finding, no, my lord. Finding starts at 414.
No.
414.
No, because these are they are dealing with complaint 1, 2, 3, 4, 5, 6, 7, 8.
My lord.
They are dealing with complaints, individual complaints.
Yes. So we are in complaint number 4.
So it is decided on the same paragraph.
Yes, my lord.
Under the same heading, it is decided.
Complaint number 4, inability of respondent to give lawful possession to the complainant. 7. 7.1 is the findings of the RERA, and then 7.2 is the finding of the appellate tribunal.
Okay. What does it say?
The appellant has argued that possession of the villa by the respondent is valid possession, which was handed over to them only upon their insistence. It is argued that the respondents on one hand have taken possession of the villa and is enjoying the same, and on the other hand is claiming compensation on the ground that the act of giving the said possession was not lawful. In this connection, the appellant has relied upon the judgment of the Apex Court reported in Nagobai so and so, reported in AI 56, Supreme Court 593, wherein in paragraph 21, the Apex Court has held that the person is not permitted to appropriate and reprobate, that is, rely on a particular transaction to obtain some benefit on the basis of the said transaction is on the basis that the said transaction is valid, and in the same breath challenge the said transaction, contending the same to be unlawful. The appellant has argued that the respondents, knowing fully well of the status of the OC and the stage of construction, had asked for possession, and after taking possession, they are now trying to take advantage. The appellant has further stated that clause 9 of the NOC for construction dated 25/6 indicates that if the authority fails to issue occupancy certificate within 2 weeks from the date of application of OC, there would be no bar in occupying the said building. It is contended that in view of such stipulations, it cannot be said that the possession given by the respondents is unlawful. The appellant has stated that the RERA, while directing payment of interest, has purportedly relied upon the proviso to section 18.1 of the RERA Act, although the statute nowhere uses the words or phrases lawful possession. Section 18 provides for handing over of possession in terms of the agreement for sale, and only on failure to do so, the proviso would come into force.
But this is otherwise academic because they have interfered with the interest applied
Interest
on
part
you.
is there, but penalty has been imposed, my lord. Lordship kindly comes to page 416, my lord. Last paragraph, last line, my lord. Liberty is given to the respondents if so advised to approach data for invoking the provision of section 61. That is for penalty. And that penalty, my lord, that can go up to 5% of the total project cost. That penalty under the act, my lord, it can go up to 5% of the total project cost. Although in this case, my lord, the penalty is imposed is 20,000 for each violation, but there is no guarantee. And my lord, he having taken possession, he is enjoying the property. My lord, photographs are there, if your lordship kindly permits me, my lord. And page 43 is his letter by which he asks for possession, my lord. 2011 document by which he was given possession.
But still, Mr. Dega, you see, even if this observation remains or not, there cannot be any estoppel against law.
There cannot be.
So therefore, otherwise also he has a right to approach.
Approach for what? Man?
No, whatever is his
No,
remedy.
his contention is that his possession is not lawful because there is no OC. But you will kindly come to page 143 first. Man. Because the conduct of the parties will also have to be seen. Man. And I had also referred before the rear panel, I had also referred to a judgment of the apex court. I can place it now also, madam, that when there is a penal provision, madam, and two interpretations are possible, the interpretation which favors me has to be taken, madam. That is not even referred in the judgment. In the written argument, I have dealt with everything. That is not even referred, madam. Page 43.
43.
43.
Yes.
This is a letter dated 7/11/2019, signed by the respondent number 1. What is he asking for, my lord? I'm not reading an entire thing, my lord. A, my lord, official possession as I don't have my own house. Complete the pending works of my flat, so and so. He requests, now lordship turns to page 196.
Yes.
He signs, my lord, along with the respondent number 2. Acknowledgement. I confirm and acknowledge that I have received the vacant and peaceful physical possession of villa number so and so, area number so and so, so and so, so and so. I confirm that the same is in accordance with plans and specifications as informed to us at the time of allotment and or approved by Guwahati Metro GMD. I have no complaints or claims whatsoever against so and so in this regard. And from the next page, my lord, next page may not be very relevant, my lord. Lordship comes to page 198 and 199 and 200 also. My contention is very simple, my lord. You are enjoying the property. I have delivered possession to you. I was supposed to give it to you within 2 years. I have given to it 1 year, few months, my lord. Timeline was till August 2020. I have delivered in 28/11. The basic 19. So basic, my lord, the purpose of enacting the legislation is that there should not be delay in possession. Now you take possession of the house, you make additional constructions, you oppose my the OC. Lordship has seen that. He is opposing my OC. He has got no connection with my OC, my lord. And then you claim compensation. And I'll be penalized for that, my lord. And page 424, if your lordship sees, this is the notice to him by the GMD for these violations.
What is the effect of this appellate judgment?
Effect is, my lord, there is a direction to me to, although it is the some part is interfered with, but there is a direction that the load sanction is insufficient, and I have to provide that, my lord. I am aggrieved by that because electricity connection, my lord, he has applied for. He has applied, it is on record, my lord. In fact, after pursuant to the judgment, I have received a letter from the APDCL, my lord, under the RTI. If your lordship is kind enough to turn to page 426, my lord.
426 is the IA.
Of the IA. Judgment is of 11/4, my lord. This is 22/5.
Yes.
With reference to the subject cited above, enclosed find with the affidavit and agreement copies submitted by so and so for prepaid meter connection for villa number so and so. So this is the application, starts at page 427. These are his signatures at page 429, my lord. 430 is his signature, then 431, my lord. $10,000 something is the wattage he has applied for. He has been granted 11 kilowatt. No dispute on that. And for the purpose of the date, my lord, lordship will kindly come to page 434. 434 and 435. This is on 11/1/2019. So, my lord, on 11/1, he applies.
You give position when?
28/11/2019. 8/11/2019.
And he applied for
11/1/2019. The mistake I made was that, my lord, in that particular project, there was a plan for 2 16-story buildings. So I had applied for 3000 kilowatt, kVA or kilowatt and kVA. It was applied for, it was granted. Thereafter, because of financial constraints, my lord, we could not carry out that construction. That was abandoned. We surrendered the load and we took a smaller load. But inadvertently, what happened, my lord, in the sanction plan, the transformer size was shown as 3000. Now he has taken help of that, my lord, and he says, no, now you have to give us 3000 kilowatt of kVA transformer. Absolutely. And the real judgment is that I am not required to take his consent for changing the transformer size, but now I have to provide whatever load he asks for.
where is that? You want interference with only that part.
Madam, I am challenging basically two parts, madam, that liberty to penalize me for possession and the transformer part.
So that he has a right otherwise also to approach. When this divorce the observations of the appellate tribunal, he could have otherwise also done it.
He has approached, the tribunal did not grant him, my lord. Tribunal granted an interest.
No. Appellate tribunal granted him that liberty. That
no,
was,
but he in the original complaint, that was one of the complaints. The RERA, the original tribunal did not grant him the penalty. It granted him interest. That was interfered with, and liberty was granted. But that was rejected by the appellate, the RERA. It was not granted, penalty was not awarded. In the absence of a cross appeal, my lord, can it be granted? Had it been a case that he had not approached the tribunal, I mean RERA, at the first instance,
that would not be permissible. That would still be permissible because an appellate tribunal, appellate court will have powers to pass such orders.
Order 41, I think 28. 28.
So that power the court has. You don't have to file a cross appeal for that.
And that is my contention before your lordship, for your lordship's consideration. I think it will start from order 41, rule 22, my lord. (33) is there, man. Rule 33.
Not a file an appeal. So therefore, as far as the electricity is concerned, we'll stay that.
Man.
in the appeal, you write, understand data counsel for the petitioner. This this appeal under section 58 of the real estate regulation. You have the type.
The Real Estate Regulation and Development Act. 2016.
Does it have any conditional conditions attached to
No,
admission of
says-
appeal
It says under 100 of the CPC.
under 100?
100.
Which provision?
58, man.
58,
32 page.
32. This appeal is this appeal under section 58 of the Real Estate within bracket Regulation and Development bracket closed Act, 2016, read with section 100 CPC and Order 41 and 42 CPC is directed against the judgment and order dated 11/4/2023 passed by the Assam Real Estate Appellate Tribunal, Guwahati in capital REAT, page 1 also, no? REAT oblique Assam, all capital, oblique appeal number 12 of 2022. The appeal is admitted for hearing on the following substantial question of law. Number one, you have made a substantial
made.
question of law.
I have
Where is that?
That in the memo of appeal itself.
Page?
Page starts from 4, man. For electricity part, man, substantial question of law 5 and 6. Man. For a lordship's consideration.
Whether having obtained physical possession of the villa on mutual agreement by both sides on 28/11/2019, whether the respondent could have challenged could have questioned the said possession on the ground that the possession taken was not lawful. And whether the mutual consent of the parties would constitute a bar on the respondent to proceed against the petitioner. Number two, the respondent having applied for electricity connection from the APDCL on 11/1/2019. Whether the Learned RERA and REAT would have ignored whether the impugn order, insofar as it relates to direction on the appellant to provide enhanced electricity load, is perverse, having been passed without taking into consideration that the respondent had applied for electricity load on from the APDCL on 11/1/2019, even prior to the taking over of possession of the villa on 28/11/2019. So as to direct the appellant to provide enhanced electricity load at his own at the appellant's risk and appellant's cost. Next para, the appellant is the appellant is permitted to raise any other substantial question of law as may arise in course of hearing. Next para, issue notice return over then give a fixed date after 4 weeks. 4 or 5 weeks, make it 5 weeks. Return over on so and so. Next, the appellant shall take steps within 3 days for service of notice on the respondent by registered post with AD. As it is by the usual process. Next, the Learned Counsel for the petitioner is permitted to collect the postal district number and submit postal tax report prior to the registered post. List on 811. Then I heard Sandeka counsel for the applicant. Next one. This interrogatory application is filed for stay of the operation of the impugned appellate judgment and order dated 11/4/2022.
23. No, the original is 22, Malab, of the RERA, Malab. The appellate judgment is 23.
11/4/2020 the same day.
23. No, Malab. 11/4 is the appellate judgment, Malab. RERA judgment. 21/9, Malab. The judgment of RERA is 21/9/2022. And the order of the REAT is 11/4/2023.
But then in your IA you have written 11/4/22.
No, that is a typographical error. Same result. It's 11/4/2023.
Look at your IA. Cost title.
No, it is 23. That's my mistake.
Okay. 11/4/2023.
In the prayer portion, it is correct.
No, maybe, but here you have to correct it. 2023, passed by the Learned Assam Real Estate Appellate Tribunal, Guwahati in same number, REAT /Assam /Appeal number 12 of 2022. Next one. Amongst others, the Learned Counsel for the applicant has submitted that as per mutual understanding, the respondent had taken over possession of the villa on as is various basis. Which is the page? Possession
190. 196.
196.
96.
By specific, by signing on the acknowledgement to the wherein it has been stated to the extent that I/we have no complaints or claims whatsoever against the appellant in this regard. In the said context, it is submitted that having taken over possession of the villa number 8-6, the respondent is now claiming that the possession was not lawful and is pursuing remedies against the petitioner by filing complaint before the RERA. It is also submitted that even prior to taking over possession of the said villa, the respondent had applied for electricity load from the APTCL on 11/1/2019, and as per the appellate judgment, this was the RERA judgment or the appellate judgment?
Appellate judgment.
The appellate judgment. The petitioner is now directed to provide additional electricity load to the respondent at his own cost. In this regard, it is submitted that if the respondent, if the applicant is not the applicant for grant of for sanction of electricity load, he would not have the power and authority to apply for enhanced load. Full stop. The learned counsel for the applicant has also submitted that as per the agreement to sell, agreement to sell dated
28/8/2018.
28/8/2018, the applicant was required to
27/8/2018.
27/8/2018. Okay. The applicant was required to hand over possessions to the possession of the said villa to the respondent within
24 months.
Within 24 months, i.e.
26/8/2020.
26/8/2020. 2020. But before expiry of the said agreed tenure, the possession was handed over to the petitioner on 28/11/2019.
To the respondent.
Oh, sorry, respondent. To the respondent on 28/11/2019. And it is submitted that having taken over possession, it is the respondent who had approached the GMDA and caused interference with the grant of occupancy certificate by an ex parte order which was passed by the GMDA on
15/9/2022. 21. 15/9/2021.
16/9.
15/9.
Where is that?
Page 158.
158. 15/9/2021.
No, my lord, I'm sorry. It is 3/11, my lord. 159.
Okay, by 3/11/2021, So accordingly, it is submitted that having interfered with the previous order of the GMDA dated 6/10/2021
Another order 59.
and only one order.
15, it is referred as one order. 610.
610 is modified.
610 is modified.
16, comma, which has caused the, which is stated to have caused the applicant to change his or to alter his position, comma. It is submitted that the issuance of occupancy certificate has been delayed at the instance of the respondent, and on the other hand, the respondent has approached the RERA to prosecute the applicant for delay in providing occupancy certificate. Full stop. In view of the said projection made by the legal counsel for the petitioner, comma, the court is inclined to stay that part of the impugned judgment, judgment and order dated 11/4/2022, passed by the learned Assam DL State Appellate Tribunal, Guwahati, in REAT Assam Appeal number 12/2022, insofar as it relates to the direction to the applicant for providing enhanced electricity load to the respondent. That will be the sting that posted. Next one. We issue notice on this application to the respondent returnable on same day. The applicant shall take steps for service of notice on the respondent by registered postal date. Within 2 days for service of notice of respondent by registered postal date. Counsel for the applicant is at liberty to correct the postal receipt number and submit postal track report prior to the next date of receipt based on so and so. The book. Otherwise, if you leave here, it will go for confiscation.
Approach, if the incident falls within one of the categories mentioned in the scheme, then naturally their activity will be considered. I'm not saying that, but so far as the judgment passed by the trial court is concerned, the infirmity of in the judgment on this ground cannot be found. This sort of argument. It is not their case that yes, he was killed in a police firing, so he should get compensation under the scheme. That part is
it's not there, but the what you call the power of the court to mold relief, even a suit is not taken away.
no power of the court to mold relief is there. But then again, the question comes in
Appeal is an extension of suit.
that power is there, I will not say. But then, as far as their prayer is concerned, they are not saying that under any other law they should be given. And here is a case where, my lord, they have not, even if we go by the plaint, my lord, they are not clearly saying that where the negligence had occurred. They are simply saying that there was a firing, he was killed, so he should be compensated.
No, for that I may have a different view.
My lord.
Subject to what you say.
My lord.
You say we are not only going to the what you call res ipsa locutor. For the time being, we are not going there. But you see, a firing incident had happened.
Yes, that is what.
So therefore, somebody was shot dead. So therefore, these people who were the assailants, you don't bring them to dock. So therefore, a stand of the plaintiff, otherwise that these people have shot them, has not been denied. We can take a view that the stand taken without leading evidence was not controverted because these people did not stand into the witness box.
Subroto Dhar was examined. He was the eyewitness. Subroto Kumar Dhar.
Because where I found that he attacked the police people with a knife,
Yes, dagger. Yes.
dagger or knife,
Knife.
and some police property was damaged. I think rifle or something was damaged.
Yes, rifle.
Correct. But that rifle again was not proved to show that he made that attack. That fact is also not disproved by you. Oh, sorry, proved by you because that is your stand.
But then Exhibit 7 itself is very clear that it was in self-defense. Exhibit 7, I do not know what is the document. I don't have the documents.
Okay. Yes, Mr. Ghosh, you start your argument because that was the preliminary point I was just asking. Who has filed the WS?
Filed by one to eight.
All of them.
All of them.
Just a minute. You've called this author of the postmortem report for examination.
Yes.
You have examined him.
Yes.
He is PW. This author of postmortem is not examined.
We have examined only 5 witnesses.
The author of postmortem report is not examined.
Not examined. And this is also not disputed in the postmortem report.
No, no,
The
no.
injury was
No, you're not getting my point. You see, I'm asking things which are
Against.
which have which are otherwise innocuous, but it leads to certain circumstances. You see, in the dead body, if I remember correctly, in that postmortem report, the dead body contains 2 holes, one in the front, one in the back. So that means there is an entry wound and there is an exit wound. Now you have to ask it to show that this was fired at what distance. The postmortem report says that the front wound was front hole was a large hole, and the second was a short one. Therefore, you see, to lead evidence of proof of this murder and to disprove that you were the assailant, the distance between the arms and the body has to be shown. If you are really at a close distance and you are shot at a point blank range, that means you are quite close to the police personnel. And if it is distance, there is some distance in between the rifle and the dead body, the holes, then you know that it was not a accidental fire, but it is intentional killing. Yes, Mr. Ghosh, there's a second point. One, it says the judgment says that it's an accidental killing. But then you see, the plaintiff also has to show that even in the case of accidental killing, the fact that it is the vicarious liability of the state to pay compensation, that is not an issue raised. You see, this what you call when you are filing a suit for compensation, the principles of tort will come out. Then this what is that?
Issue number 4 was there.
Fletcher versus what is that?
Yes, yes.
Whether the state Assam is vicariously liable. Issue number 4.
But that how did you prove it?
This issue has not been discussed also.
Not been discussed.
Not discussed.
Show the judgment.
Page 29.
29. Issue number 3 has already been decided negative. Therefore, there is no vicarious liability. Without observation, also the issue has been. Because Mr. Ghosh, if the issue is framed about vicarious liability, then there's another connotation of that. That liability will be borne by the state only when you prove the negligence on part of their employee. So once a vicarious liability, to settle the state with vicarious liability, the primary liability has to be proved. And that in issue number 3 was negative. That is causing the entire anxiety. That's why I'm asking the question. I started with questioning Mr. Mazumdar. Whether the state has a policy, why that state policy should not be implemented and made payment, which is otherwise. That's why with all this, I started with Mr. Mazumdar. But please continue, Mr. Ghosh. You wanted to say something?
No, my lord, yeah, your lordship is examining the records.
You want it?
If your lordship is
No, no,
examining,
no,
it's
no.
all right. I'll see afterwards.
I'm looking at it in a different perspective.
And lordship may always.
No, it's okay. I won't read it right now.
And I'm having only the memo of April, plain WS and the judgment, nothing else.
No, we also have the same thing. So you and we are at the same pedestal.
Ghosh is in a better position.
Huh?
Mr. Ghosh is in a better position.
Is this citation referred here incorrect? Because I'm not getting that. Page 28. Citation 2008 3 GLT 456. I've not been able to open that. Second citation is also I'm not being able to open up. 2008 4 GLT 117. What is your circular for payment of compensation? And
Different, I think. One such notification.
I think this time it should have been 2 lakh. This 90, this is a case of which year?
There are-
Date of shooting?
There are subsequent notifications also. Next of kin.
Accident took place on January 2005. No, February 2005.
February
2005.
2005. No, no 2005. Huh? Okay.
Three to 2005.
Can you ask in the meanwhile someone, Mr. Mazumdar,
Yes.
what is your at that time? What was the compensation which was required to be paid under your policy?
I can find it. Five. Incident to 2005. 2005.
Because Mr. Mazumdar, if anything else is not available, then I must still jump into the particular side road of Article 21, and then say when the life is lost. It's a state's duty to compensate because number one, the firing for whatever reason
Firing,
is an admitted fact that the state
Firing is
has the
established.
state's employee has done it.
firing by policeman is established.
Huh.
Next question is whether in an incident of this nature he will still be entitled to compensation or not. That has to be seen. Because a person killed in an incident and a person who is involved in assaulting the policeman and then getting killed because of the incident, whether it will still cover this incident, the notification will cover this incident or not, as to say. I don't know, but I'll see the language from this point of view.
No, your stand is that because of the assault there was a damage to your rifle.
No, not damage. They exhibit 7 language manner that it is because of self-defense.
No, you're pleading somewhere. Your case is that it's pleading.
Yes.
No, damage to the rifle.
Rifle.
And
That is the
to rifle
damage.
is there, but in self-defense is also there, I think.
No, just Mr. Wasn't there?
Right.
Just look at your side. You'll find a TV. Just portray a picture that somebody is coming with a knife. There's a movie going on. There's somebody coming with a knife and one has a rifle which has got hit. And this man does not attack him with a rifle. But what he does is that he shot him. You see, there is some flaw in the story there. Number one, in a rifle, had it been in a regular way to shoot someone, then the damage would have been to the nozzle. What is it called? Rifles.
Nozzle light.
Nozzle. The damage would be there. But if it is the backside, that means in the wooden butt, then it would mean that the police were not in the attacking mode. in a self-defense, what do you do? What is the normal tendency in a self? In a, I forgot those things. You see, there's a book called Fake Law. You have seen that? It's by a barrister in UK. He writes by a pseudonym of Fake Law. The author's name is something else. Sorry, is it by barrister? He just writes by barrister. It doesn't disclose the name. And in that book, there's a what do you call it, a chronicle story of the rifle laws in England. How far the right of private defense would go. It's a beautiful book. I think someday I'll give it to you. You see, right to this self-defense would go to what extent? If somebody is with a knife and he is shot with a rifle, is it a equal right of defense? Because the IPC says no.
Medical officer was examined PW5.
PW5. What does it say? Bro, this is something I have not read.
PW5.
No, in the judgment there must be some reference. What did he say?
In the judgment, there is no reference. It only said PW5.
Just put your two things. This is in page 108. This is IPC. I've given a faint tick mark. 106. Yes, in the
Exception 3.
No, before that.
Thirdly.
Thirdly. Then down below. Something. Because just assume that there are again sequences. Number one, it was the duty of the states to show that this man was placed in a what you call list of hooligans or list of known criminals. Number one. So that is why if you see him, then you feel that he may be threat to you. That is number one. Number two, there is a duty protocol for opening fire. It will be true that he was empowered, because then you come in the category of secondly. Secondly, that down below.
Yes.
You have the power, but you have exceeded it. And that's not the state's case.
Which like culpable homicide is not murder. If the offender in exercise in good faith of the right of private defense of person or property exceeds the power given to him by law and causes the death of person against whom he is exercising such right of defense without premeditation and without any intention of doing more harm than is necessary for the purpose of such defense.
So this is time.
No, here, my lord, this so far as this exception is concerned, the opening words of this section is under section 300.
300. It's an
Now
exception.
it is when exception 1
Hmm.
is something else, and this is exception 2.
All are independent.
All are independent.
Hmm.
And it will not be, it says culpable homicide is not a murder. It's only defining the exception in which case culpable homicide will not be a murder. Like here in this present case, we are concerned with the situation where he has exercised his private defense. These people, few of them were there. They,
No, you see,
according to
there
them,
has to be a sequence. There has to be a sequence. He came with a
one. You'll also permit me to read the cross 2-3 lines of cross examination. Possible things will change of PW4. He says, "I am brother during cross examination by defendant number 5. I am brother-in-law of plaintiff and also the brother of the deceased. The deceased was involved in a criminal case regarding chopping of hand of a policeman in Harichara, Bajar earlier. And the case was pending when the deceased died. So our burden is gradually coming down. Secondly, my lord, it is not a fact that deceased was an unruly person and he used to create menace whenever he was on leave. Now, also he used to do, it's a statement, my lord. He used to do unruly things at the Karichara in festival time or in other festivities. So these are admissions on the part of PW4.
I'll show you something. So this part, I never read, so I'm able to locate it immediately. About the requirement of law to have permission from the higher authorities or from the executive magistrate to open fire. That I've never read, and yes, I won't be able to locate. This is something which I read, so I have found out to you. The second flag down below the thing. Page 1198.
1198.
You see, there's a requirement to have this bad character road maintained in the police station.
Bad character, yes.
So therefore, merely an incident of crime is not sufficient for the police people as a general to brand him as a person having a bad character.
This term, I know this is there. And what I'm saying is, man.
There are two, in fact, two forms: bad character 1A and B.
Yes. B also.
I'm showing you this for a different reason. The reason is a presumption of a bad character will not come unless it is entered in the role, number one. And therefore, if when you take a stand that he was bad character, then it is the duty of the burden would be on the
State.
defense to show that he was a bad character and could have been shot.
Admittedly, these materials were not brought
These were not
before
there.
me. My submission will be when PW4 admits that he's a bad character man and he regularly does it. Now where is the
So that's
need
why
for proving?
that's why I smiled when you said so. But this is what is the reality.
Man, yeah, this
The
is
legal,
there, man.
even if he says,
They must-
the legal burden
Man.
would again be on the state. The divorce.
And normally it will be on the state. I'll humbly submit, my lord, when they clearly admit, PW4 clearly admits that he is a man, my lord, not simply a bad character.
No,
He has chopped off the hand of a policeman.
No, no,
So
it is
how
not the language.
to
And I am the brother of the plaintiff and also brother of the deceased. Deceased was involved in criminal case regarding chopping off the hand of the policeman in Katli Bazar,
Yes.
and the case was pending with the deceased died.
Yes.
It is not a fact that deceased was an unruly person and used to create massive whenever he was on leave.
Next sentence.
That's okay.
Next
But you see,
sentence.
It is
first
not-
part dissolves the second part.
Yes.
No. Second, next sentence.
Next
He used to do unruly things at the Karichara in
Correct.
festival time or in other festivities. So two things.
I have not seen.
He has
them.
chopped off. He had earlier chopped off the hand of a policeman, number one. And number two, it is a clear statement, my lord.
He was a service in
he-
Assam Rifle.
He used to do unruly things at the Karichara in festival time or in other festivals. He's a bad character man. They themselves are saying,
No, but you see, still when there is a law,
my lord.
we can't presume him to be bad character. Unless his name is entered in the Thana for the purpose of a bad agent.
Technically, my lord, yes, my lord. Technically, for us to say that he's a bad character person, I have to do all these things. I'm not on that one. Here is the case we are examining only the validity of the order passed by the Land Trial Court, decree passed by the Land Trial Court, that there is no negligence on the part of he has to prove it's a suit for compensation for and vicarious liability of the state for the negligence committed by its agents or officers. He has to show that they were negligent. Now, when his own document is showing that they were not negligent as such, but there was a scuffle and he was doing these, they were also for their self-defense, might have fired a shot. And the persons who were examined, nobody is an eyewitness. There is not a single eyewitness.
He says one is there.
No.
PW6. Oh, PW4.
4 is also not there.
4. No. Kindly read the evidence part. বাড়িতে আসার কিছুক্ষণ পর বাহিরে হাল্লা চিৎকার শুনিয়া আমি বাহির হইয়া কীর্তন সামনের দিকে রওনা হই। বাড়ি হইতে বাহির হইয়া যাওয়া আসার পর দেখিতে পারি জীবন সিংহ, কমল বর্মন, রশিদ উদ্দিন লস্কর ও দিনরাজ পুলিশ লোকল আমার ভাইকে বন্দুক দিয়া শেখায় দিয়া আসিতেছে এবং পুলিশ দলের মধ্যে হইতে জীবন সিংহ, দীনেশরাম রাজবংশী ও আমার ভাই সুদীপ ধরেন লক্ষ্য করিয়া অত্যন্ত উদ্দেশ্যে পাশে বর্ধিত ভাবে 17-10-12 মিটার দূর হইতে আমার উপর
10-12 meter.
10-15
meters.
উপর পচালি করে সঙ্গে সঙ্গে আমার ভাই মাটিতে পড়িয়া যায়। ওই সময় আসার সঙ্গে থাকা স্বপন নামের ভৌমিকের উপরও একটি গুলি লাগে।
The second person was also injured.
Yes.
Was he examined?
Exactly.
He was examined as witness.
Yes.
Where is that? In the judgment? Where is that?
Bhomik was not examined.
Huh.
Second person was not.
Second person was not examined.
Yes, sure. Yes, second person was PW3.
PW3.
Swapon.
Huh.
Yes.
So he destroys your case. PW3 destroys your case. So he says that he doesn't know who shot him.
So shot by the police. It was
No, that's
it was
okay,
said.
but that is his evidence.
Only name has been disputed.
This statement
Name,
says,
who has
I
fired
cannot
that
say,
time?
I cannot say who fired.
Who fired? But in statement, police fired.
But you see,
No, no.
Mr.
Police
Ghosh, when it's a police personnel killing person, you have so easy way to prove that he has killed, because you see, you will call for an armory report. Because you see, a person who is handling these cases of what do you call these damages and compensation, they must know the manner. Number one, you'll have to get a armory report, and then second, you'll have to get a report from the police reserve that who was allotted with this what do you call, who was allotted with this rifle. Third is that you'll have to ask for a report about the ballistic because when this comes, report of armory, it will also give you a FSL report with regard to the bullet which is fired, which bullet is fired, it is from which gun. You will have to call for that record from the police reserve as to who are the police personnel who were allotted duty on that day on that place. So then your sequence is complete as to who are the persons there and who and from which gun it was the fire was made. And then you see the second point is that whose rifle was damaged. So if it is a rifle damaged by X and shot by Y, then you know how to make out a case. But everything is lacking here.
PW3 statement, my learned friend has not seen. At the time of firing, I came to my house for dinner. And while I was taking my meal, I heard the sound of firing. So how can he get injured, man? He was at home.
So for that you have answers. In Kalapahar, people who are far away from that firing range, their houses got damaged because of firing.
So, he was not in the spot. He says, yeah, he got injured. He was not there at all. PW4 says he also got bullet injury and he was at home. Anyway, for awarding compensation, there has to be clear case made out that there was negligence on the part of the persons. Firing is there, this cannot be denied, it has been established. But the negligence part in the face of the finding that that was for self-defense. I also would like to see this latest notification of 2014 about the grant of compensation. Persons killed.
Just read this evidence of the PWs. Let me,
PW, my lord.
this PWs, let Mr. Ghosh read that. PWs. But this is in Bengali. I would not be able to read even if I take it home. So just. What does PW1 say?
May I read?
Yes. Mr. Mazumdar, please also go with it together
yes,
so that I understand.
I'm reading.
আমি শ্রী রূপাধর, দিস ইজ ওয়াইফ। আমি এই মোকদ্দমার 1 নং বাদিনী। আমার স্বামী জীবিতকালে আসাম রাইফেলে একজন সদস্য ছিলেন এবং তাহার রাইফেলম্যান সম্ভব ছিল নাম্বার 2301748। তিনি বিগত 2005 ইংরাজি সময়ে জানুয়ারি মাসে 2 নং বাদিনীর অন্নপ্রাশনের জন্য ছুটি নিয়ে বাড়িতে আসেন। বিগত 2/2/2005 ইংরাজি তারিখে দারিয়ারঘাট দুর্গাবাড়িতে নাম কীর্তনের আয়োজন করা হয়েছিল।
What is the date?
2205।
Yes.
এবং আমার স্বামী ওই কীর্তনে যোগ দিয়েছিলেন। রাত্রি অনুমান 11টার সময় 11টার সময় 5 হইতে 9 নম্বর বিবাদীগণ হঠাৎ কীর্তনের বাহিরে আক্রমণ করে আমার স্বামীকে গুলি করে হত্যা করে। বন্দুকের শব্দ শুনিয়া কীর্তনে থাকা লোকজন বাহির হইয়া দেখিতে পারে যে 5 হইতে 9 নং বিবাদীগণ আমার স্বামীর গুলিবদ্ধ দেহ ঘেরাও করিয়া রাখিয়াছে। বিবাদী আমার স্বামীর শরীরে লাথি মারিয়াছে। পরের দিন আমার স্বামীর ইনকোয়েস্ট দ্বিতীয় এবং ময়না তদন্তের জন্য তিনি মরদেহ হাইলাকান্দি সরকারি হাসপাতালে প্রেরণ করা হয়। হাসপাতালে কর্তব্যরত ডাক্তার KZ চৌধুরী ময়না তদন্ত করেন। KZ চৌধুরী PW5 এবং আমার স্বামী গুলিবিদ্ধ হইয়া মারা গিয়াছেন বলিয়া প্রতিবেদনে স্পষ্ট উল্লেখ করেন। 6 হইতে 9 নং বিবাদী তাহার আহত 2 ব্যক্তি যথাক্রমে শ্রীমতী অঞ্জনা নাম ভৌমিক ও শুভ্র দে হাইলাকান্দি সিজেম আদালতে 2খানি কমপ্লেন পিটিশন দিলে তাহা কাটলিছাড়া PS 1705 ও 1605 নম্বরে নথিভুক্ত হয়, কিন্তু পুলিশ কর্তৃপক্ষ তদন্ত পক্ষপাতিত্ব করে ইহার তদন্ত করেন নাই। অপরদিকে 7 নং বিবাদী সম্পূর্ণ মিথ্যা উদ্ধৃতিতে আমার স্বামী এবং অন্যান্য লোকদের বিরুদ্ধে একখানি এজাহার কাটলিছাড়া থানায় দখল করে, যাহা কাটলিছাড়া PS কেস নাম্বার 5/05 নম্বরে নথিভুক্ত করে এবং তদন্তে অন্যায়ভাবে আমার স্বামীর মৃত
Katlachara PS case number 5/2005.
It was filed by police. And another 2 PS case 17/05, 16/05.
Another case is Katlachara PS case number
17/05.
This is by
by শ্রীমতী অঞ্জনা নাথ ভৌমিক, অঞ্জনা নাথ ভৌমিক ও শুভ্র দে, another 16/05.
This is by
16 by Shubhro De.
Subhra, SUBHRA.
Yes.
Yes.
অপরদিকে 7 নং বিবাদে সম্পূর্ণ মিথ্যা উদ্ধৃতিতে আমার স্বামী ও অন্যান্য লোকদের বিরুদ্ধে একখানি এজাহার কাটলিছাড়া থানায় দাখিল করে, যাহা কাটলিছাড়া PS কেস নাম্বার 5/05 নম্বরে নথিভুক্ত করে এবং অত্যন্ত অন্যায়ভাবে আমার স্বামীর মৃতদেহ দুর্ঘটনামূলক দেখায়া উক্ত FIR এর ভিত্তিতে কাটলিছাড়া UD কেস নাম্বার 3/05 নম্বরে নথিভুক্ত করেন, ফাইনাল রিপোর্ট দাখিল করে। Regarding police case, police filed by the police. ঘটনার পর 5/2/2005 ইংরেজি তারিখে 6 হইতে 9 নং আসামি বিবাদীগণের বিরুদ্ধে হাইলাকান্দি CJM আদালতে একখানা কমপ্লেইন কেস দেই, যাহা CR 5905 নম্বরে নথিভুক্ত হয়। 1 CR কেস এবং বিচারের জন্য মাননীয় মুন্সিফ নাম্বার 1 আদালতে বিচারের জন্য প্রেরণ করা হয় এবং ওই মোকদ্দমা আমার স্বামীর মৃত সমাপ্ত রিপোর্ট কাটলিছাড়া থানা হইতে তলব করিলে কাটলিছাড়া থানার অফিসার ইনচার্জ আদালতে যে রিপোর্ট জমা দেন তাহার ভিত্তিতে দেখা যায় যে পুলিশ কর্তৃপক্ষ তাহাদের সহকর্মীর অপরাধ আড়াল করার জন্য অত্যন্ত দায়সারাভাবে এবং পক্ষপাত দুষ্ট হইয়া আমার স্বামীকে ঘটনার জন্য দায়ী দেখাইয়া আমার মৃত আসামিগণের অনিচ্ছাকৃত ও আমার ও আত্ম স্বাক্ষরের জন্য হইয়া বলিয়া কাটলিছাড়া PS UD কেস নাম্বার 3/05 মোকদ্দমা রোধ করে ফাইনাল রিপোর্ট প্রদান করা হয়। মহামান্য আদালতের সাক্ষী প্রমাণ প্রেরণ করিলে কাটলিছাড়া পুলিশ রিপোর্ট যথা গ্রহণযোগ্য নয় দেখিয়া পান আসামিগণকে বিচারের জন্য মাননীয় সেশন জাজ হাইলাকান্দি আদালতে বিচারের জন্য প্রেরণ করেন এবং তাহার সেশন কেস নাম্বার 5/06 নম্বর নথিভুক্ত করেন। আসামিদের বিরুদ্ধে
5/06.
Yes.
50.
50/06 সেশন কেস।
50, huh? 50 sessions case.
Yes. আমার সাক্ষ্যের প্রমাণ দাখিলে কাগজগুলি নিম্ন
Just sessions case 50 is
সেশন কেস 50/06
for that chopping off of hand.
No, it was filed by against a final report. Objection has been raised. Then
No, that won't go to sessions. It will go to the magistrate where there is a committal proceeding. Sessions will not take what you call objection as to FR.
CJM.
no,
It will be the CGM because sessions case will not be registered.
here it is
Session
written
case
police
will be
report
only when there is a
গ্রহণযোগ্য
charge.
নয় দেখিয়া
Sessions case will
Fine.
be registered only when there is either charge sheet or a committal by the way.
After committal, even
After
on
committal.
charge sheet it can't. Commence.
ল্যাঙ্গুয়েজ ইজ মাই লর্ড পুলিশের রিপোর্ট গ্রহণযোগ্য নয় দেখিয়া পান যাহা আসামিগণকে বিচারের জন্য মাননীয় সেশন জাজ হাইলাকান্দি আদালতে বিচারের জন্য প্রেরণ করেন। দ্যাট ইজ কমিটেল।
Still
দেন আমার সাক্ষ্যের প্রমাণ দাখিল কাগজগুলি কাটলিছাড়া পিএস কেস নাম্বার 1605 মোকদ্দমার এজাহারকারের সাক্ষীর নকল যাহা প্রদর্শক 1
No, just wait. There's some gap. I'm not being able to follow. Okay. Okay, yes.
Then number 1, Katlichara PS case number 1605, Exhibit 1. Katlichara PS
Just exhibit 1 is
Katlichara PS case number 16 of 05, Ejahat of Katlichara.
Okay. 16 of 2005.
16 of 05.
FIR certificate copy.
Yes.
Right.
Number 2, PS case, Katlichara PS case 1705.
This is also FIR.
FIR. Original of which was called for.
This, what do you call this? There's two people, Anjali Nath and Kamal Burman. Sorry, Subra De. They were also examined as PWs.
Subra De and Anjana Nath Bhumik.
Anjana Nath Bhumik.
Anjana Nath.
She was examined. These two were examined or not? Subra De.
Subra De.
Huh. Shubha is a male or female? Male.
I think male.
Okay.
Maybe male.
No, I don't know. I'm just asking you because.
Depend on how it's pronounced, unless Srimati is written, because Shubhra may be female, Shubhra may be male.
Not Shubhra has not been written. Shubhra has been written.
Shubhra. Acha. Okay. Okay. They were examined as PW?
No.
Anjana Nath Bhumik and Shubhra De.
They have not examined.
Anjana Nath Bhumik was the informant in Katlichara PS 17 of 05. And in Katlichara 16 of 05, Subra De is the informant.
16, yes.
They were not examined.
Then Exhibit 3 is the Katlichara PS case number 5 of.
But then tell me, it's just a question which occurred to me. If the people who have lost the FIR, if they are not examined, how do you prove that FIR?
FIR 1 is Exhibit 1 is certified copy.
No, certified copy is okay.
And second one, original has been produced. Original has been called for.
I'm not on that.
Author of the.
No. If the author has not proved the FIR, how do you prove the FIR? I'm asking about the legal evidence. Is a FIR proved by somebody else? Is a good proof? Okay, we don't, but no, exhibit 3, what is that?
Katlichara PS case number 5 of 05.
Okay,
This is exhibit 3.
exhibit 4,
4 is UD case number 3 of 05.
3 of 05.
Yes, in relation to exhibit 3.
No, can't be.
Yes, UD case 3 of 05. When this case was 5 of 05 was FR, then UD case has been registered as 3 of 05.
No, no, no. I'm telling you why. You see, Katlichara PS case number 5 of 2005 is by Head Constable Bashiruddin
Yes.
Laskar against the deceased under
No.
section 326. Deceased is that your husband.
Deceased and other.
No, 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 no. I don't know about others, but what I've read, I'm saying others I have not read. So this is relating to the chopping of the hand of the earlier constable. So therefore, UD case can't be registered on 3 of 2005 on the basis of 5 of 2005. Can't be, unless there is an evidence that victim died, whose hands were chopped off.
The judgment, there is a reference, page 16. In the WS, page 16.
16.
Small d, page 16.
Huh.
The following incident, the Katlichara UD case number 3 of 05 was registered along with Katlichara PS case number 3 of 05, 16 of 05, 17 of 05, were duly registered and duly investigated. Then next paragraph, F. UD case number 3 of 05 was registered on the accidental death of Sudeep Dhar. The KTC PS case number 5 of 05 was registered on the FIR of
So there are two different things they are saying.
Bashiruddin.
There are two different things they are saying.
Manner.
3 of 2005
Yes.
is not on the basis of 5 of 05. There are two separate things which are being stated.
Yes. 5 is different.
5
5
has to
is
be
registered
different.
on the FIR of Bashiruddin
Bashiruddin is the head constable.
Yes.
Somewhere you will find that he is a head constable
against the deceased.
against the deceased.
Yes.
So therefore, UD case will not be registered on the basis of 5 of 05. That's what I'm trying. That is the point I'm trying to make.
Ah, yes.
Correct.
Yes.
So these are unconnected, and comma is incorrectly put.
Yes. Unconnected. And then KTS case numbers, PS case number 16 of 05 was
16
registered.
and 17 are two cases registered against the police in the present
Yes,
case.
yes. One by Anjana Nath and the other by Jivan Singh.
Shubhra Day.
Yes. And 1705 was against Kamal Verma.
Yes. That's why I'm asking that question whether without the author being.
Yes, sir. Actually, FIR has to be proved by the person who lost the FIR.
No, I don't know. I'm not.
Yes,
I'm
sir.
not suggesting anything. I'm just asking that question.
Well, absolutely, madam.
What is exhibit 5? 4 is UD case 3 of 05. Okay. Exhibit 5.
Exhibit 5. UD case 3 of 05.
But then what is 4? 4 you said is 3 of 05.
For
UD
UD
case,
case
4 is
number
UD
3 of
case.
05 মোকদ্দমা এজাহার স্বাক্ষরিত নকলের যাহা প্রদর্শক চায়ের যাহার আসল তলব করা হইয়াছে।
I didn't get it. Please explain.
UD case number 3 of 05 মোকদ্দমার এজাহারের স্বাক্ষরিত নকলের যাহা প্রদর্শক 4 যাহার আসল তলব করা হইয়াছে।
So that means a requisition.
Requisition.
Requisition is exhibit 3.
No, no, no.
4, exhibit 4.
Exhibit 4 is a certified copy of
No, no.
the UD entry. It's not an FIR,
No, no.
it's a UD entry.
Huh.
So, UD is registered. And KTC UD case number 3 of 05.
No, you see, if I remember correctly, my experience of 25 years back, if a UD case is registered, it is entered into the register in the PI office. And then there is a form prepared of the UD case where the particulars of the deceased person are noted.
Yes.
Correct. These are the two things which are available,
Yes,
and the FIR or whatever is there, or GD&T, whatever is there, that forms a part of the UD case.
UD is unnatural death. Unnatural death. case.
Unnatural death case.
Yes.
So that is the only things.
And
which are there.
Exhibit 4 is the certified copy of that.
Okay. So what is 5 then?
5 is UD case number 3 of 05 again. Mokodamar final report.
Final report. Okay.
Final.
Okay.
Certified copy of final report again.
Okay. So now we are left with 6,
Yes.
6, 7, 8.
Yes.
Few things are more.
6 is inquest report.
Inquest report.
Certified copy. All are certified copies now.
From the LCR, can you just flag that? Then exhibit 7.
7 is CR case number 59 of 05.
CR case.
Yes. In that case, police report submitted in that case, madam.
CR case.
CR case 59 of 05.
59, 2005. Here what had happened?
Madam?
What had happened, you are saying?
The exhibit 7 is the certified copy of the report submitted by police in CR case number 59 of 05.
Police report.
Police report.
Exhibit
7.
7. Exhibit 7 is the
Police
complaint.
report.
Complaint.
Police report.
CR case.
Police report. CR 5905.
Police report.
Police report.
Yes.
Okay. Then what are other exhibits?
Then exhibit 8 is there. Postmortem report.
Report.
Postmortem report.
Certified copy. Exhibit 9 is ATCPC notice. Exhibit 9.
ATCPC notice. But then, Mr. Ghosh, you see this notification of 2014. It may take away some of your right, which I was so eagerly thinking of as an alternative remedy to you.
So possibly there is a line, I have not read it today, but possibly there is a sentence somewhere. If he himself is involved, something like that.
The last entry, Mr. Ghosh, last entry there, if he is not at fault.
Because I am appearing in another case where earlier notifications are also there.
Only that last line is referable. Otherwise, it goes into the 3 lakh rupees bracket. If he's otherwise killed in by the police, then he gets 3 lakh rupees otherwise. But why I'm saying this may be to a disadvantage, because there is a finding that he is not at fault. Because civil finding will now haunt you, even for that to be. In that book, there are many incidents given. where gun control laws were visited, revisited, then these were done. So there it shows, there are examples given there. That a man is trespassing as a way to as a shortcut to go to some place, and he was shot. The question is that their right to the defense extends to the property, and so therefore it says that it was correct. Then there was an amendment to the laws, because that can't be unless you are threatened. The question is that uh, a person came into the house, knocked at the door, asking for some address, and since there was a knock, the owner of the house took it as an affront to him and shot the person dead. So the issues are that to what extent the right of defense would be there. Merely entering into your property, asking for direction would constitute those. So it's in the fake law. He analyzes all those theories of and then says these are. He has his own commentaries for that, but he gives very good examples of that right of private defense, to what extent it can go. But then, Mr. Ghosh, you possibly cannot come out of it. Mr. Ghosh, you really cannot come out of it. It's your evidence. You not only proved certificate copy. Three.
Panelist, PW2 panelist, important.
No, you see, whatever questions I am putting, the evidence goes against you. Whatever questions I am asking.
Panelist is the PW2, man.
No, you see, I'll tell you why. Why everything is going in a disarray. This, you have exhibited this exhibit 5. This exhibit 5, there's one statement which I am reading, the police lodges this entry at 12 noon on 3/2/2005. Amongst others, he said, Sri so-and-so, late so-and-so of so-and-so, and some other magistrates have created trouble with arms, cookery, etc. after taking liquor. They have tried to control them, but could not. Subsequently, IC, along with those constables, ABC 50 Jivan Singha, with their arms ammunition, rushed to the spot and found that they said Sudip Dhaur with his party abused them with filthy language and attacked them with hajari, arms, lathi, etc. The IC with staff tried to control them, but in the meantime, Sudip Dhaur made a hit with his kukri upon Jivan Sinha and Kamal Burman, causing their rifle being damaged. Finding no other alternative way to save their life, both constables opened fire to their private defense, resulting in Sudip Dhaur got injuries. Now, when you are proving this, you are also proving that this the arms, there was an assault, there was an arms, and therefore it is also your burden to show that you did not do that. It's a written evidence which has come into record, and you have proved it. Now, there is one point. Proving a document, proving its contents are two things. No. Please read this, both of you. What do you? What is your appreciation of this? Both of you, please read together. What is your individual appreciation of this? So, Mazumdar, please share it, Mr. Ghosh also. Please come over this side. You have it?
No, this is inquest report.
Inquest report.
Whole, should I read the whole one?
No, the next page.
Yes.
One part I have down below. Yes, where your hand is.
Yes.
That paragraph.
A writer is found.
No, in the top you will find that there is one bullet entry, a big bullet entry, big hole. In this page you have two bullet entries, right?
In this page there is nothing.
Huh?
No.
He finds it is in the straight position, superior position. He finds a bullet hole. Then he turns the body. He finds a second bullet hole.
Chest and
Huh?
chest and liver. Chest and liver.
Huh. First is superior position. Is in the front page, I think. Then
One big injury seen
Huh,
in the
yes, that page.
lower portion of the chest, right side.
Huh.
and one big piece of flesh is seen coming out from his injury. This injury, our little, sorry, one little injury hole likely to be hit by bullet is seen on the knee of the left foot of the deceased, and blood is seen coming out from this injury. Now I turn the dead body upside down and examine about any cut, stroke, injury mark. A little injury mark, stroke, hole likely to be hit by bullet on backside, right portion of the deceased, and blood
Yes.
is.
So just a moment here. Mr. Mazumdar, from this it appears there are 3 bullet injuries.
Yes.
One at the knee
Yes.
and one in the front, one at the back.
Yes.
3 bullet injuries. But this so then I was wrong. When I was reading it, I read it wrongly somewhere. I thought there were 2 holes, would be one entry hole, one exit hole.
Yes.
So that's not the case.
No.
In fact, there are 3 bullet injuries to him.
Yes.
So how do you appreciate that piece of evidence, Mr. Mazumdar and Mr. Ghosh? To this witness, doctor witness, did you ask about the, sorry, the inquest was approved? No. By the author?
PW5.
PW5 is he's the executive magistrate.
No.
Then?
PW5 is the who has done the postmortem.
No, this is inquest report.
Inquest report is by Deepak Bhuya. He was not
Deepak
examined.
Bhuya was not examined.
Deepak Bhuya was not examined. And this postmortem report, how many bullet injuries he found in that postmortem report?
Yes, I had done an autopsy on the dead body of Sudeep Dhar. So and so.
No, first of all, you go through that postmortem report. Tell us how many injuries he found there.
In the postmortem.
Then you come to the evidence. Inquest has 3 bullet injuries. I think others may leave. We won't have time to take up any other matter.
In backside also there was
an injury.
Not injury. When it was turned back, it appears that when the victim turned his back to the assaulted, he was shot on his breath.
Correct. So you see, there are 3 bullet entries. If there is, Mr. Ghosh, what I'm trying to ask you is simply, there are 3 bullet entries, bullet injuries. Number 1, if there is a entry injury, there must be an exit injury. Otherwise, the bullet will be found in the dead body.
Exit wound is there.
So there will be many punctures. If there are 3 bullet injuries.
1, 2, 3, 4. 4 are exit wound caused by the exit of projected from.
You see, then if there are 4 exit wounds, there will be 4 entry wounds also. So there will be 8 punctures in the chest, 2 punctures in the leg. One will be an entry wound and one will be exit. 10 bullet injuries, 10 holes would be there in the body.
Massive damage. The right leg
Otherwise, otherwise the bullet will be found in the body.
resistance. The damage to the liver resulted in massive damage inside the result in victim's death. Death must have occurred very soon after the victim was shot in the both of on back of the chest. Was found inside the body. Findings is given the damage to the liver resulted in massive hemorrhage inside the
No, that is okay.
and
We are not disputing that. I'm just
the-
trying to find out how many injuries were there. You see, once you don't take that plea of access to the right of private defense, if that is not
no,
established by the
that is why I am reading, my lord. Seen after the victim was shot on back of the chest. That means back of the chest he was shot.
who says that?
Postmortem report.
Postmortem report. Okay. So that entry wound is in the backside.
Backside.
So where is the exit wound then? There must be a corresponding exit wound.
No projectile could be found inside the body.
So that means it has gone out.
Out.
Projectile has gone out. That means the bullet has gone out.
Due to massive following grievous damage on the liver caused by bullet wounds on the chest fire from the high velocity rifles.
You're following my question. You see, if the projectile has gone out, there must be a corresponding exit wound.
In the report, it is there, exit wound. Exit wound is there.
In the report, it is there.
Yeah.
So, in total, how many punctures you are finding in that postmortem report? There should be 4 then. And where is that exit wound? Which place of the body is the exit wound?
It appears that when the victim turned his back to the absolute, he was shot on his back. The cause of the wound number 1, projectile that caused the wound number 1 destroyed the liver and caused massive damage to the limb of the right kidney and stomach. After firing, resistance of the resist on the ulterior chest wall. The damage of the liver resulted in massive hemorrhage inside the illegible, and this resulted in victim's death.
So there is only one bullet entry, that means.
Report that the findings are that.
Mr. Ghosh, my idea is to understand the nature of attack made. If there is one bullet entry and one exit point, then we understand there is only one bullet injury, and that caused damage to the vital parts. It pierced the liver, it pierced the kidney, and then it went out. So you see, I'm just telling you, the liver would be somewhere here. Here I forgot. Somewhere below the chest.
Left hand side.
Left hand side,
Left hand
and the
side.
kidney is down below in the navel side. So that means, you see, what I'm asking you is that if a bullet is, that means a bullet must be shot. If the bullet has to pierce the liver and kidney and go out, then you see the angle must be made. That means he was shot in very close range, has to be in his near his chest, which would pierce here and go out. So exit wound would be
in front. Exit wound is in front. Because it says
it
that
was shot from back. Okay, huh? Okay. So there must be a corresponding, you see, corresponding matching exit and entry wound. So if it is in the back, from back it can't hit the liver and the kidney at the same time.
The wound number 1 and number 3 are the entry wound caused by the entry of projectile from the fireman. The wound number 3 and 4 are exit wound.
No, 1 and 3 you are saying is the entry. 1 or 2?
1 and 2.
1 and 2 is the entry wound.
And
1 is where?
And 3 and 4 are exit wound.
No. You,
Number
Mr. Ghosh.
3 was caused.
Where is one?
Mr.
Where is
Ghosh,
one?
I am trying to find out the.
Where is 1?
Where is 1
Yes.
and the corresponding exit wound? Then I understand.
1, the projectile that caused the wound are destroyed the liver and caused massive damage to the lower limb of the right kidney and stomach after fire resistance of the ribs on the anterior chest wall. The damage to the liver.
So it does not relate to the bullet. Which bullet caused which injury? It doesn't say there. Mr. Ghosh, I'm trying to understand. You see, one bullet will not hit two parts.
Two bullets.
So there are 2 bullets.
2 bullets. One and 2 entry, exit, and
Okay. So there are four wounds. Okay. And what about leg? Leg, no injury.
no, it is not.
Okay. Just pass it on. This causing some. Understand. No, just I'm trying to read that to find out.
Which,
Postmortem report.
postmortem.
Postmortem, if it shows 4 punctures only, that means inquest report is incorrect. Inquest report says that there is an injury in the leg. The leg injury was never found. No, that you will find in the first page down below. In the first page down below, you will find first page of this.
This one is first page.
Here down below, yes, here where your hand is.
Yeah.
Description of injury.
This one is more detailed description of injury.
Okay.
More detailed description of injury.
Just read that.
About the wounds, my lord, they are talking about injury number, wound number 1, 3, 3, 4. 2 is somehow missing. They made a mistake somewhere.
Number is missed.
You just pass that evidence and let me go through it once. This cross of the doctor, please read that. Cross examination
Postmortem.
of the doctor.
Cross. The original postmortem report is there in the record. I am not an expert in arms ammunition, From my common sense and for the reason that no remark of projectile was found stuck inside the body. Bullet of original gun can pass through the human body, but it depends upon the range.
That is examination in chief or cross examination.
Cross.
That is the only cross.
Only cross.
But then, Mr. Ghosh, there are missing links. You'll have to tell us more. It's only because this person has died because of police firing. I'm hearing so much. You have to give me something to show that the crime against the state was proved. Because you see, there are 2 or 3 things. Number one, that they have exceeded their right of defense. How we have established it. The second is it, you see, someone was proved by preponderance of evidence, because this is a civil case, that either of these 2 people, that Jeevan Singh and Kamal Burman, they have shot you. Some evidence is required to be there.
But from the PW2, it transpired that after the bullet injury, police was searching this Sudeep Dhar in the house of the PW2. Then he said that no, he was not found. But while coming out from the home, he found that dead body was lying in the road.
Who said?
PW2. Mihir Dev.
Please read that part.
বিগত 2/2/2005 ইংরেজি তারিখে রায়হাট দুর্গাবাড়িতে নাম কীর্তন আয়োজন করা হয়েছিল, যাহা আমার বাড়ির নিকটে। রাত্রি অনুমান 10:30 সময় আমি উক্ত কীর্তনে ছিলাম এবং তখন কীর্তনস্থল থেকে হঠাৎ গুলির শব্দ পাইয়া আমি বাড়িতে চলিয়া যাই। আমি বাড়িতে যাওয়ার পর পুলিশ আমার বাড়িতে গিয়া সুদীপ ধর আমার বাড়িতে আছে কি না জিজ্ঞাসা করে। আমি নাই বলিলে পুলিশ আমাকে বিশ্বাস না করিয়া আমার সঙ্গে তল্লাশি চালায়, কিন্তু পায় নাই। আমার ঘরে তল্লাশি চালায়, কিন্তু পায় নাই। পরে আমার পাশের মিঠু দেবের বাড়িতে পুলিশ যায়। ইতিমধ্যে আমি আমার বাড়ির সামনে রাস্তায় বাহির হইয়া এবং তখন দেখিতে পাই পুলিশ শ্রী সুদীপ ধরকে পিছন হইতে তাড়া করিতেছে। means police is chasing him. তাড়া করিতেছে এবং 15 মিনিট দূর হইতে 10-15 মিটার দূর হইতে শ্রী সুদীপ ধরের উপর 2 রাউন্ড গুলি করে। গুলিবদ্ধ সময় জীবন সিংহ, কমল বর্মন, রশিদ উদ্দিন ও দীননাথ রাজবংশী ছিল। সুদীপ ধরের উপর জীবন সিংহ ও দীননাথ রাজবংশী গুলি চালায়। গুলি আসতে শ্রী সুদীপ ধর মাটিতে পড়িয়া গেলে পুলিশ তাহাকে লাথি মারে। আমি তৎক্ষণাৎ কীর্তনের দিকে যাই এবং কীর্তনস্থল হইতে লোকজন ঘটনাস্থলে আসে এবং সুদীপকে জীবিত দেখিয়া লোকজন বাড়ি আনার জন্য বলে। আমি ও কয়েকজন গাড়ির খোঁজ করিয়া গাড়ি না পাইয়া ফিরিয়া আসি এবং দেখি যে ইতিমধ্যে সুদীপ ধর মারা গিয়াছে।
PW2.
PW2. So if it is a case of self-defense, police was chasing him. And in cross, the occurrence took place in front of Katlichara Durgabari. My house is Katlichara. Katlichara and Daryarghat are on the opposite bank of the river. There is no electrical light on the road of the village. It was a dark night. I was inside the mandop. I have given my statement in my affidavit.
No, but on issue number 3, the trial court records that PW2 had adduced contrary evidence by stating that in his cross-examination that he did not see who fired the gun, as he did not know whether Bashiruddin Laskar Jivan Singh Kamal Burman performing law and order duty in the arms or not. There is the
Yes.
finding of the trial court.
No,
So,
this is there. Cross I am seeing
Cross
through
I am-
cross. I did not see who fired by gun.
Yes.
So his evidence goes.
But poor person, 2 rounds of fire.
No,
In
no,
the
he was not
postmortem
there at all. There are
report
two,
is
two sentences. One is, on hearing sound of firing, I went to my house. I know them. Then I did not see whether the above named persons were performing law and order duty. Then next sentence, I did not see who fired by gun. This evidence that they have chased and they shot from behind goes. He didn't see. There is some amount of the incident, how the incident has taken place, that can be seen from Exhibit 9. Possibly it's a police report, forwarding report, I think.
Exhibit 9 forwarding report.
Yes.
That is forwarding report of
CR case number 59 of 05. There is a mention that 5 rounds was haphazardly shot to save their life as well as private defense.
'59.
Yes, CR case number 59 of 05.
Arising out of which PS case?
This one is
CR case.
CR case.
There was no CR case.
one CR case.
Complaint case was there.
Yeah, filed by us.
Filed by you.
Yes.
Oh, Exhibit 7. Police report.
Yes, Exhibit 7.
Yes, yes.
There is a narration of the incident by OC Katlichara PS.
That's what I showed you in the 3rd page.
3rd page, yes. In the incident, 3rd page, lower portion, the incident is described now.
Huh.
The 5 round was shot haphazardly. And how he brandished his kukri and all, injured those persons, security persons.
Just pass that. So, Ghosh, I don't think you make out a case. You read the evidence of PW1. PW1 does not introduce those concepts of exceeding the right of private defense or shooting it at a close range, or saying that the what you call chasing of that witness and then shooting him. All those things have not been introduced at all in the evidence.
In fact, that is not the plain case also. That is not the plain case.
No, not that. You see, but as a counsel, you read the written statement before drafting of the evidence. In the written statement, there is a defense taken of why that was done.
Right.
So in the evidence, is it not required to say something about that written statement?
Okay. Well, that's what I'm saying. What I'm saying is, my lord, in the the endeavor of the plaintiff is not to prove the negligence. They are simply saying this is death has taken place, you have to pay compensation. And this particularly the witnesses, well, PW just now we have seen. He has not seen the incident. He is describing. He is making a story, and here it's not a criminal case, but it's preponderance of probability. Exhibit 7 shows that there was an incident, scuffle, and then haphazardly 5 bullets were shot. So, in view of all this, and his conduct is also coming up from his own document. One of the witnesses has gone to the extent of admitting that yes, he was creating trouble there. So, with all this, to what extent the plaintiff has been able to establish the requirement of negligence so that he is entitled to compensation. Tortuous liability. And as you are saying, Mary, in this case, if they have to prove negligence, they have to show that for private defense, they have exceeded the limit.
It has to be introduced. Something
Yes.
has to be done. Otherwise, you take you see, it's a otherwise you take a generality or fallback on that what you call compensation that since the person has been shot dead, the liability to the extent of the 2014 circular has to be paid. Because Mr. Mazumdar, so please, I would say it. You see, when it's a police force firing, it's very easy to track
Yes.
because you have those what you call the bullet numbers given.
Yes.
You see, even the negative now can be proved. I can portray a story. You see, what has happened is that there's a UD case, and in the UD case, there's a FR issued that there was the police is not at fault. They make no attempt to have those bullets getting examined. Therefore, it's when the best evidence is available. You see, now what you are saying is that 5 bullets were haphazardly fired. So these 5 bullets has to be accounted for. And therefore, in your harmony, you will have a record of what happened to these 4 bullets. It was fired because either that or the loss of the cap has to be reported again. The bullet cap, if it's not given, that you have to make an entry.
Empty cartridge.
Empty cartridge was not found, or it was what you call it was in a place where it couldn't be retrieved. Those things must be entered. And from that, you can identify the arms from which the shots were fired. If that is not done, then there's a reverse burden saying that this was not corrected because they wanted to save the police personnel. The OC is present, in charge is present when this takes place. So therefore, who inquired? There must be some what do you call investigating officer. Who is that?
Normally, in a criminal case, the prosecution will prove all these things.
No, even in the civil case, we can always ask that who is the person, and if these people are of the same, then we say they're trying to save it, and therefore, fastening of criminal liability or vicarious liability on a state is not very difficult. Now, here is a case where the state takes a defense that there was rightly or wrongly, defense is taken that the rifles were damaged. You did not need any evidence to show that. Principles of freedom promise of evidence that you had suffered some injury for which you had to retaliate. That is an evidence which will come from the state. So if the state doesn't prove it, 114 illustration G, can't it be applied?
In my humble submission, the documents which they have produced, but so far as two things are there. So far as the use of weapon is concerned, that to some extent has been established. So when we are taking the plea of self-defense, that means it was fired by us. So to that extent, it is established, one should say. And the next is whether it was used for self-defense or not. Now, when their case is for compensation for negligence on the part of the agents of the state, then they have to show that the documents which they have produced will itself say that it was in self-defense. Their documents, Exhibit 7 is very clear. So now their burden gets shifted, Mallory. They have to show that no, it was not correct. It is their document.
So that is the onus, not the burden.
Onus, not burden. Burden always remains static.
Okay.
And there are materials also which came out from the mouth of the witnesses in the cross-examination that he is not a man of good character. He himself created trouble there for the witnesses. These materials will show that it is in self-defense. And he was holding a kukri, he was using it, he caused injuries to the security personnel.
No, the police never sees that.
No, it is his case.
No, it's your defense that they assaulted the rifle with a.
No, what I'm saying is Exhibit 7 says, Exhibit 7 contains the entire story. They have proved Exhibit 7, they do not dispute Exhibit 7. Exhibit 7 is not disputed, it's their document. Exhibit 7 carries a story that he was using kukri, he caused damage to the rifles, and he caused damage to the
That's what I was saying. That's why I was saying the witness has to introduce something in the evidence to disprove the stand taken in the written statement. And this document has been proved by the plaintiff. The difficulties is that this is happening in Hailakandi Bar. And what has happened to that? The cross it has come. You filed a human rights commission. What has happened?
That instruction I.
Let me go through it, the record. We'll take it up next week again. Mr. Ghosh, in the meantime, you'll have to show us something which can permit me to take recourse to Article 21 and then perhaps not by way of goodbye, but by invoking Article 21. But then also has to be in consonance with the evidence led. So once an evidence is led, I can't override the evidence and then direct the state to pay compensation. It must be within the scope of legal evidence which is there on record. We'll fix it. Just go over there and need some time to read it. We'll see it next week.
It will be on 3rd, then Manu. 3rd is just
3rd October.
Manu. Tuesday.
My prognosis says not the opposite to Puja here. Mr. Ghosh, can you or Mr. Mahindra, can you have this Bengali evidence translated for me? You have a copy. Mr. Ghosh has it. Can you have it translated for me?
I'll do it.
Yeah? Get it done. Because you see, our registry, the people in our registry is involved in translation of judgment on the direction of Supreme Court. They issued a direction so that the local language, some judgments has to be uploaded.
They are occupied.
Huh?
All of them are preoccupied.
Because there's a direction we can't.
Your Lordship is talking about Exhibit 7.
No, the Bengali evidence.
Evidence.
In fact, especially PW1, because I need some material to show that this evidence was led with regard to the negligence of the state in handling the matter. Seven is a bit legible. I can.
Possibly 7 is in English.
Huh?
7 is in English.
No, especially PW1. The evidence to show what actually she has said in the court.
My learned friend can do it, man. He's asking for compensation, let him also compensate.
No, that is okay. But
I'll,
we'll try to take it up next week. Just try to get it. Especially PW1.
PW1.
But she is the lead person, she lead witness to say that.
Yes.
Try to get
Let
it
him
done.
do it, man. I don't have a copy also. I don't have a copy of this evidence.
No copy we can ask the court to provide. That's not a
No,
issue.
let us do like this, man. There are
Cross sorry. Only cheap.
either he can do it or I also can do it, as your Lordship.
It will You have copies of that deposition?
He has.
You have copy?
He has.
Just give a copy. Mr. Mazumdar can also assist us.
Well,
But one can do. No point two people doing it.
yes, yes.
If you're doing it, then we don't give the burden to Mr. Mazumdar.
So with Lordship is thinking about on third.
Third, both sides it will be presented. The argument of both sides remains inconclusive. List again is a parted matter on 3/10/2023. Given by So, SK Ghosh in the counsel for the petitioner shall translate the evidence in chief of PW1 in English.
1, 2, 3.
Huh?
1, 2, 3, and 4.
2, 3.
All-
No. You see, number this 2, 3. If they are not eyewitnesses as per the judgment of the trial court, then perhaps we did not go into it. The only purpose is to examine if there is something material available. By
I
which-
translated all of 1, 2,
Let
3,
him
and
do.
4.
Let him do only if he wants to.
Okay, if you can do it,
Because,
it's welcome.
4 has said he has seen the.
No, if you can do it, it's welcome. Because PW1 must introduce the evidence with regard to that negligence and what do you call, and to dispel the stand taken in the written statement. So therefore, I'm saying PW1 for the time. If you can do it, it's okay. PW1. 1 to 4 कर दियो. But if others are not done, I would not mind. You did not get the certified copy of Exhibit 8 postmortem report.
Postmortem report is.
No, the doctor says that the original postmortem report is not there in the record.
Certified copy.
No, then again, there is a question if that is so. This is certified document. You have evidence act with you? Postmortem report incidentally is not a what you call public document. It is prepared by a medical doctor who is a government servant, but this is not a public document. Unlike other documents, postmortem is not. So if the origin is not proved, this is otherwise will be inadmissible in evidence.
The original was called for.
No, but then the loss has to be also proved that this original was called for and then not produced, and therefore no others. I can agree. You see, that will not do.
Then I will have to go through the record whether it was called for or not.
Just see that the postmortem report.
LCR.
Postmortem report is not a public document. You see, I'll show you why it is not. Mr. Ghosh, I'll show you this why it is not. See 293 CRPC. In CRPC, these are the documents. Okay. So these are six things. FSL would otherwise be admissible without calling of the author, but postmortem reports that a doctor is not covered by 293. So for all the other six, there is an exemption available that you can prove the document without calling for the expert, and therefore the IO can prove the FSL report.
petition or file it. Else.
Because Mr. Ghosh, there's one more theory. I don't know. I wouldn't be able to recollect it right now. This postmortem is not a regular course of ordinary business for the hospital to do it. They do it on a requisition being made by the police. And therefore, to do that, a GD entry is required to be made when they are transmitting this dead body to the IO, sorry, to the hospital for making a postmortem. So even if there is an FIR or whatever, but to send it is done through a GD entry. So it's not a regular course of ordinary business for a hospital to do postmortem report because they can't do it unless there is a police requisition. But this part, immediately if you ask me, I'll not be able to cite a authority on the point. But insofar as the not a public document, this is 293 is sufficient. So can the next date you just tell us? You're not taking any other matters, Mr. Das.
Interim is then item number 35. Interim order is then item number 35.
Just tell the court master. If there's an interim order, others will be rolled over. We are not fixing a date right now in other matters. It will be rolled over, but will be taken off.